All rise. Justice of the Appellate Division, Supreme Court, First Department. Nanith, over this time, this is the Appellate Division. From here, your attendance shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. Before I begin the call of the calendar, let me notify you that we have almost 7 hours of requested argument time. Needless to say, I am going to require you to ask for that time that you need, not the time that you want. Okay? Understand that the clock is for you, not for the court. So if your argument is brilliant and it requires more questioning by my colleagues, I will allow the questioning to continue. Okay? Please ask for what you need, not what you want, so that I don't have to do it for you. People versus Heartless. How much time?
Take 7 minutes off of my 15.
That's nice, because that's all you were going to get. How much rebuttal?
I don't need the
Oh, okay. And 7 and 7. Okay. Pastor Berg versus August Acorn Center.
respond. 6 minutes.
You'll get 3. You're here by yourself. Thank you. Rios versus St. Barnabas. Okay. Hold on. So the appellant is, how much time are you asking for? Okay. And, okay. Okay. So 5 and 1, 5 and 5. State of New York versus Andress A. Okay. All right, 6 and 1 and 6. Nanith versus 590 Madison Avenue. Okay. Okay. All right, 6 and 2, 4 and 4. Connect One Bank versus Legacy Builders.
For appellants, we request 6 and 2.
Okay. 4 and 1. Do you have a cross appeal? No. So you don't get rebuttal time. All right, 6 and 1 and 4. Landa versus Freriedman. 5 and 1 and 5. You gentlemen have been here before. People versus Jason Jocks. Submitted. Mandor versus Rafalski. 5 and 2. 5 and 2 and 6. Scalamandre Oliveria versus Juda Contracting. Sorry about that.
Appellants requesting that Jason Smith Prohot VK be granted leave to argue, and he can speak as to his time.
Okay, granted. Oh, you haven't been here before. How much time would you like? 7 and 1 and 7. Sanchez versus 1649 Nelsco. 4 and 2, please. Okay.
Respondent 4.
4 and 2 and 4. Bowden versus Summit Glory.
Appellant booking 5 and 2, please.
Okay.
Plaintiff respondent 4, please.
Respondent appellant Marlboro 4.
Okay.
Respondent appellant Summit Glory 4.
Okay. Okay. So let's do 4 and 1. Plaintiff 4. 4 and 4 and 1. Okay? All right. Jeffries LLC versus Izzo Capital. How much time? 7. Okay. 5 and 2 and 5. Ochoa versus 270 West Street is settled. NE and Infant versus Park Cash is submitted. First case on the calendar, People versus Heartless. You may proceed.
Okay, thank you. Good afternoon, Your Honors. I reduced my time because the briefs are very extensive in this case.
I
They were
agree.
overstated, and we were granted additional permission to supplement the brief by the statements of the co-defendant, Barry Wiles. And just briefly, Judge, this is a case where severance was requested. They're requested in many cases. This is a case, though, where what we really had here was two prosecutors. There was a devastating opening given by co-counsel for Legal Aid Society that said that the defendant, Mr. Heartless, got into the car, threatened him with the gun, and he took off, and that's the reason why he drove the car
Did he
away.
use those words, threaten me with a gun, or did he simply said, my client thought that he would be next?
He said, drive, he said, Mr. Heartless said, drive, 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 in the opening.
Yes.
And so Judge Dwyer said, well, maybe that was just the operation of his mind. And so originally he was going to grant the severance. He thought about it over lunch. He came back and said, well, let's think it through that way. And my response at the trial was, you know, the trouble here, judges, this seems like this is going to be a pattern that's going to go throughout the trial. And that's exactly what happened.
But counsel, my understanding from the record is that the court was very clear to the jury that opening statements is not evidence. And as you know, the whole drive statement by Mr. Wiles was not admitted. And the focus was really to say that Mr. Wiles was not the shooter. That really, I mean, in a simplistic state, I don't say you have to agree with me.
No,
But it's against that backdrop that.
well, that's why severance should have been granted, because if it was simply that, then a curative instruction would have been sufficient. But it went far beyond that, because what the lawyers did with respect to each witness, that they put the gun in the hand of Mr. Heartless. And by the time summation came,
Well, there was plenty of evidence to establish that, no?
there was evidence to establish
Right?
that.
The gun was found in the back seat with him,
Yes,
right?
right. And so with respect to that issue, the gun was found on the floor. And so that was one of the issues that was contested, that the officer who approached the car, the testimony about whether or not he actually saw Mr. Heartless reach down to the floor, we brought out.
Do you have to reach down to drop a gun on the floor of a car?
You sure don't, Your Honor.
No, you don't.
But when
You don't even have to move your upper torso to achieve it, right?
You're right. But when co-counsel for the co-defendant gets up and brings out that Mr. Heartless did in fact reach down to the floor, we have a lawyer for a defendant who, on an issue that's unrelated to their charges, that are really serving as a second prosecutor. He did a better job of it than the prosecution did itself.
Are you suggesting that at no point, as a part of your client's defense, did you not suggest that perhaps the gun belonged to someone else in the car?
Did not suggest that.
No?
I just want to go back. You know, isn't it true that co-counsel did not specifically implicate the defendant or even, well, let me say it this way, you know, did not implicate the defendant and really focused on the lack of evidence against Wiles, right?
If that, no.
No?
If that were the case.
So you're saying that they did specifically
Yes,
implicate?
because by the
I didn't
time,
read that.
Yes, by the time we got to the summation, the lawyer for the co-defendant said that Mr. Heartless fired the gun. He got into the car with the gun. And so we built right up to what, at the beginning of the case, was my concern, that this is, and what became problematic was that Mr. Wiles gave a confession, and the prosecution decided they weren't going to use the confession. And so what the lawyers for the co-defendant did was they basically tried the statement without it, and the prosecution objected to it. They said, you know, this is improper, Judge. They're using the ruling as a sword instead of as a shield, and they're working through Mr. Heartless. They're the statements of Mr. Wiles, that he was in fear, that Mr. Heartless had the gun, and he only drove because of that. Because a part of their examination of witnesses and their arguments.
But didn't Mr.
Yes.
I thought that the premise was that Mr. Wiles took off because there was a shootout right in front of where he was double parked, right? And that he peeled off, and other people were running as well. So why is that? Why is he was in fear? He was afraid to be shot. Why is that so unusual, given the set of circumstances? He didn't know where those shots were coming from.
Your Honor, you're right. That's not unusual, but that's not what happened here. The examination here went beyond that.
Did the examination go into Mr. Heartless actually being one of the shooters?
Yes, the shooter. Because by the time they summed up, they closed, saying that Mr. Heartless was the shooter and he got into the car with the gun. By the time we got to the summation, they had put the whole statement that wasn't going to be put into the evidence by the prosecution at play at the trial. And it really denied Mr. Heartless an opportunity to have a fair trial here.
So you're saying that the prosecution could not assert that your client was the one who committed the shooting and got into this vehicle. They couldn't assert that on the basis of the statement being precluded.
That's correct. They couldn't do it with respect to Mr. Wiles, because the prosecution.
And that was the only evidence in this case that showed circumstantially that your client was involved in this.
No, Judge. There was other evidence by Officer.
Like the person that
Was by-
shot, right?
Well, not necessarily, because they said that they didn't know who shot them, but that was another issue. That's a later point in the brief.
One of the police officers saw your client get into the car with the gun.
Yes,
One.
yes.
And you got all the forensics in terms of all that residue on his sweatshirt.
And
blue
washing the
jacket
hands.
notwithstanding.
Right.
So putting Wiles aside, there was a boatload of evidence here to implicate your client.
Yeah, but you know, Judge, when I'm trying a case and there's one prosecutor is one thing. When you're trying a case and there's another prosecutor and the lawyer for the defendant
So
is
if
doing
we
a better
disagree with you that you didn't face a second prosecutor, you lose that.
That's correct.
Okay, all right,
Thank you.
thank you.
Good afternoon. May it please the court. Rachel Bond for the people. There was no requirements for severance here. Not only were these statements not introduced by any party into evidence before the jury, so therefore there was no Bruton violation. The joint trial was proper under Mabubian as well. The core of the defenses weren't in irreconcilable conflict. This is in fact very similar to other cases that this court has just recently found that no severance was required, such as People versus Elaine and People versus Stokes, both the Ralph and the Keith case, one from 2017 and one from earlier this year.
But the point is that Wiles' defense attorney did in her opening allude to testimony that was supposed to not be included in the trial, because there had already been a severance motion. The judge already made a decision. You start the trial, the defense attorney gets up, makes the opening statement, and then the prosecution asks for a mistrial based on that. So that's really what caused the problem. I mean, it had already been decided, and that snuck in, and did that sort of taint the whole trial with all the other problems, as your co-counsel has suggested?
So two responses to that. So first, the defense attorney for Wiles did not ever say that this statement, this drive statement, was made by Wiles to the police, never said he made a statement to the police, did not attribute that statement to anybody. And in fact, in her summation—
Just use the words, sort of.
Just use the words. And in fact, in both her opening and her summation, made it very clear that it was meant to be an interior monologue. If you read the opening, she says—
What does that mean, an interior monologue?
Well, if you read her opening, she says that in what she's saying, that when he sees the defendant get into the car, he thinks, what's going on? Drive. Is Ra referring to the defendant? Hurt. Drive. Am I next? Drive. It's very clear that it's this internal monologue. And in fact, and then in her summation, she makes the argument that Wiles is afraid of the undercover officer, not of the defendant. She specifically references Officer Verna, who's standing outside his unmarked police car, and says that he's afraid of him.
And that was the vehicle that was following the Mercedes
Yes.
all along, which Mr. Wiles thought was the person that was shooting at them.
Yes, that was their argument, yes, in summation. And then additionally, after the prosecutor initially did say that he thought maybe a mistrial might be warranted, he did say, I need to confer with supervisors. And then later he came back and said, after reading the transcript of the opening and I think talking to supervisors, he disagreed that there was no mistrial needed. And I think it's very easy to see that he knows the content of Wiles' statement to the police. He hears that and immediately thinks, oh no, she's trying to get this statement in through a back door. But then when he actually read the transcript, he realized that's not what happened. That's not what the jury's going to think because nobody ever said anything about a statement to the police. And moreover, the Wiles attorneys did not act as a second prosecutor. They in fact told the jury in their summation that it was up to them whether the defendant was guilty, that they should listen to the arguments that were made. They also, their cross-examination.
Did their summation put the gun in the hands of Mr. Heartless and have Mr. Heartless as the shooter?
In portions of their summation, they did refer to defendant as the shooter. However, they also told the jury that their arguments were being framed, assuming that you find defendant Heartless guilty because Wiles was accused of aiding Heartless. So in order to find Wiles guilty, they had to find that Heartless shot the victim. So they said that. They said, this is all assuming, everything I'm telling you is assuming that you find defendant Heartless guilty. So it's really just a way for them to not say, I think I had in my brief a line that in their summation, they could say, you know, defendant or Heartless, rather than saying the shooter who is accused of being Mr. Heartless. You know, it's a way that they can just streamline what they're saying to the jury. And moreover, their cross-examinations of the trial witnesses really largely focused on those witnesses' credibility, distancing Wiles from the forensic evidence, and whether or not they knew Mr. Wiles, not on defendant particularly being the shooter. And they didn't, in fact, bring out any new evidence that wasn't brought out through the people's case about Mr. Heartless being the shooter. And so if your honors have no further questions, we ask that you affirm. Thank you.
Thank you.
Thank you very much.
Thank you. Esther versus August Acorn Center. You may proceed.
Good afternoon, Your Honor. Brennan Breland of Kaufman, Borges, and Ryan for the respondents. Assuming the court's familiarity with the nature of this case, I'll proceed simply to one argument in response to an argument advanced by the appellant in their reply. In mischaracterizing the Supreme Court's ruling as granting summary judgment on grounds not argued below, appellant overlooks the fact that the Supreme Court granted summary judgment on numerous grounds, including the chief argument advanced below, that being causation. Appellant's position is this court should adopt an approach to racial discrimination in employment cases that would hold if a plaintiff advances a claim for racial discrimination in employment, there is no prima facie pleading requirement, and any summary judgment motion is dead on arrival, mischaracterizing this court's rulings in two primary cases, the Bennett case, and I don't recall the other one cited. I will note that the Masicki case cited by the appellant for the proposition that courts must restrict their rulings to arguments advanced by the parties is belied by this court's jurisprudence. In fact, 2 weeks ago, the Second Department ruled in the Robles case that an appeal was to be dismissed on grounds not argued on appeal and not argued below. The argument had not been advanced by any party at any point in the proceeding. It is well within the Supreme Court's jurisdiction to grant relief based on arguments not advanced by the parties. That's not what happened here. Arguments were advanced as to causation. The court ruled on causation, on the absence of evidence regarding racial animus, the absence of evidence regarding an adverse employment event, many other things. I would urge this court not to commit the same mistake the appellant does in overlooking the breadth of the Supreme Court's ruling on the motion below. With that, I'm subject to your questions, and failing any, I'll rest on my brace.
Thank you.
Thank you.
Rios versus St. Barnabas. You may proceed.
Good afternoon, Your Honors.
Afternoon.
This is a medical malpractice case involving allegations of failure to timely diagnose an ectopic pregnancy on the part of the respondents. The appellant presented to the St. Barnabas Hospital Emergency Department on July 9, 2000.
Yes, but she didn't follow instructions, did she?
No, actually, she did follow her.
No, she didn't. She was supposed to go to the clinic within 48 hours.
And she did that.
And she was supposed to have blood work done.
And she was told that the clinic was closed. When she went to the follow-up appointment at the clinic on July 11, 2014. She saw the midwife there. She was told she was told that the clinic was closing. They couldn't do blood work that day because the clinic was closing at 4 p.m. She was told to return in a week.
And when she was leaving the building, she saw that the lab was open.
And she relied on the midwife.
And she didn't open the door to see. She is told that she has a potentially life-threatening situation going on, right? That she needs this blood work so that they could see and determine how bad her situation was becoming. And instead of going to the door where there are people that she can see through the glass, she leaves.
She followed the instruction that was given to her by the midwife.
Let me ask you this question. She was also instructed if you don't go to the lab, you can also go to the emergency department, correct?
She wasn't instructed that by the midwife.
Well, let's assume that she was also instructed to go to the emergency department, but did not. What was the reason for not going to the emergency department across the street? Because I thought there were two instructions.
She was told that there's documentation indicating that she was instructed at the emergency department visit on July 9, 2014, that if she could not go to the clinic on July 11, 2014, she should come back to the emergency department. But she in fact did go to the GYN clinic on July 11, 2014. So that instruction from 2 days ago at the emergency department no longer applied, and she was going off the instructions given to her by the midwife on July 11.
Let's stick with the initial time, and I'm talking about the 9th, because from my recollection, both the plaintiff and her husband signed off on the fact that they received instructions about how life-threatening this was, and they needed to follow up. Is that accurate?
I don't think her husband was there.
Yes, he was.
Yeah.
Okay, very well.
That they verbalized their understanding of the need of a follow-up in 48 hours, because it was stressed that it was life-threatening and the importance of going in 48 hours.
And she did that.
Counsel, this was a verdict after trial.
Yes, Your Honor.
At which your client testified?
Yes.
And at which the midwife testified?
Yes.
And the issue that we are discussing right now is whether or not the lab was open and whether or not she was instructed to go to the lab by the midwife, because that particular instruction did not appear in the records. Is that it? Am I correct?
Which instruction?
The one that the midwife gave her, go immediately to the lab and have your blood drawn, because we need to know. We need to know whether or not certain numbers have increased to know if you're having an ectopic pregnancy.
So the medical documentation of the July 11, 2014 GYN clinic visit does not reflect that she was instructed to go to the lab.
Exactly.
Blood drawn that day.
But the midwife says that she did instruct the Ms. Rios to go to the lab that very day.
That's what she said.
Right? And she had finished, although the lab closed, according to the midwife, at 5, the examination of Ms. Rios had ended way before 5, somewhere between 4:07 or 4:20.
Yes, that's according to the midwife.
According to the midwife.
5, but
So-
according to the plaintiff, she was told it closed at 4.
Right. So now we have a credibility issue that has been left for the jury to decide.
Yes, and that credibility issue is affected by the point, the evaluation of that credibility issue is very significantly, substantially affected by the issues I raised in my papers.
I
Well,
understand.
I'm sorry, may I?
Yes.
A lot of this is focused on what is unusual, to send a trial subpoena, when we know we're dealing with a discovery issue and that there was a full and fair opportunity to really question the midwife during her deposition. The discussion of times really wasn't explored. You claim it would surface during the trial, correct?
Yes, it was served during the
Okay,
trial.
and with all that Sturm and Drang, at the end of the day, by the way, I went through this record, and correct me, was there a charge conference?
I believe there was a charge.
And did you put in a missing witness charge as your request? Because I couldn't find it in the record.
So I wasn't at the trial personally. I'm informed that there was a missing document charge request made, but it's not in the record. In the record.
And not only isn't it in the record, there was no objection made at the close of the case, when the judge gave the instructions, say, Your Honor, I object to not giving a missing witness charge here. I'm sorry, missing document charge with respect to the very document you were seeking, because you were really seeking to get the lab times, correct?
That's correct. That's correct. There was no objection to the charge as given at the time it was given.
Okay.
Thank you.
Thank you.
Okay.
May it please the court, my name is Nicholas Herzler. I represent defendant Chaperone in this case. Your Honors, this was a jury trial. The jury had extensive evidence before it that my client did not.
But before the trial, there were some depositions, no? I mean, there always are.
There were depositions. The depositions, it was brought up where the plaintiff testified that she was told that the lab was closed, and then at the defendant's deposition, it was brought up that she said that it was open.
Right, and this was never pursued any further during the discovery stage of the case.
Precisely. It would have been after the deposition, plaintiff should have served a post-deposition demand for a copy of the lab schedule.
And I think the judge mentioned that at some point also.
That was mentioned, absolutely. The judge noted that that issue had not been explored and that it was untimely raised during the trial, that the plaintiff was attempting to get discovery for the first time during the
Although, so then there were some subpoenas served during the trial, is that correct? For the records, to see if there were any records that related to the opening hours of the lab at the relevant time, right?
Not exactly. The court gave permission for plaintiff to serve a subpoena on St. Barnabas. However, the plaintiff did not serve a subpoena. Instead, they informally emailed a request to St. Barnabas for the prescription and the lab schedule.
And there was never any response, and the trial ended, and sort of nothing happened about that, right?
Correct. There was not enough time for the hospital to search for documents. It was 9 years after the event. The plaintiff had waived the issue during discovery. The hospital could have searched for documents during the course of discovery. And so the issue having been waived, and then the plaintiff having waived the request for missing document charge as well, at that point, plaintiff has no basis to challenge the verdict based on evidentiary errors. And because the verdict is more than supported by extensive evidence in the record that my client did not depart from the standard of care, the judgment should be affirmed. Moreover, the jury did not even reach the issue of proximate cause. So any argument by plaintiff as to an error would be harmless.
He answered no on the first question?
Correct.
Is that correct?
Correct. I think the court understands my argument, and I'll rest on my papers unless the court has questions.
Do you have a question?
No, okay.
Thank you.
Thank you.
Good afternoon.
Good afternoon.
May it please the court. My name is Samantha Quinn. I represent St. Barnabas Hospital. I will try to be brief because many of the points have already been raised by my co-counsel.
Well, counsel, one of the issues was raised by your friend was the fact that there was cross-examination of the plaintiff about her cocaine and marijuana use on July 10th, the day before, or around that time, and they objected to it as being prejudicial and irrelevant. But didn't the plaintiff submit all the hospital records, which include that notation?
Yes, in fact, it was on the 17th, when a pre-anesthetic note was entered into the hospital record, and Ms. Rios admitted that she had done coke and pot 7 days prior, which would have been the 10th. So after the 9th, and prior to the return visit on the 11th. So that was it was part of the hospital record.
Which was not objected to?
No.
The entire record?
Regarding the issue of the schedule, first of all, it was never established that there was actually a written schedule for the lab. This request came in mid-trial, and it was 9.5 years after the events in question. The plaintiff was deposed in 2016, and at that point, she claimed that the lab closed that she was told the lab closed at 4. Nurse midwife Chaperone was deposed 2 years later. It was a 39-page transcript. She was never asked any of these questions. And Judge Jerez appropriately commented in the record, this is at 5:01, okay, I do believe that these are questions that should have been asked at the deposition. So you know, these are questions that if you had been asked, you would have elicited the information. It seems like there was a very short deposition of the main defendant in this case, and that questions that should have been asked perhaps were not. Additionally, plaintiff's counsel at trial effectively waived this issue. In the record at 490, Mr. Capel states, the only issue we are trying to protect against is somehow that during the examination, a document comes before us that we haven't seen before that contradicts the case.
Would the lab hours be something that would be contained in the medical records?
I don't believe so. And again, Judge Jerez asked that the trial counsel for St. Barnabas make a search, which she tried to do, but it was so late that she did not get a response to that or the issue of the prescription. Additionally, the plaintiff's own expert admitted that the lab was open at record at page 451. Question, so would you agree with me, doctor, that Ms. Rios went down to the lab as directed by Nurse Chaperone, that in fact the lab was open? Answer, it appears so. Question, and doctor, she didn't go inside, correct? Answer, I don't believe that she did.
So the jury heard this testimony, right?
Yes, they did.
So even if we didn't have the records, or you didn't have the records, which obviously you didn't have the records, they heard this back and forth and could make their determination based on that.
They did, and they decided that they would credit the testimony of the defense witness as opposed to the plaintiff, and that's within their province. That there's absolutely nothing to indicate that this verdict was against the weight of the credible evidence, and nothing to indicate that it should be set aside.
Thank you.
Thank you.
Just briefly to respond to a few points raised by respondents. Based on midwife Chaperone's own brief, the court actually ruled in plaintiff's or appellant's favor with regard to the issue of the subpoena for the lab hours. But then inexplicably, the court allowed the case to go to the jury without those lab hours having been.
Did the plaintiff make any type of objection during the charge conference or whatever? Judge, wait, we have to, follow up on this issue. I mean, shouldn't that have been your responsibility? Maybe not you, but whoever is representing the plaintiff at the trial?
I mean, I think it would be a shared responsibility on the part of appellant and the court.
Why is it the court's your people dropped the ball? You had all the information you needed from the EBT to make the discovery request that you now claim is the end-all, be-all of your case.
Actually,
and so you wait until trial, all of a sudden a light bulb goes off, and that becomes somebody else's problem. That's not how trials work.
Actually, we didn't have the information. The midwife never mentioned that it was.
Also, are you saying that what was discussed by your adversaries regarding the depositions and the time, the issue of what time the lab was open or not open, you didn't know that?
We didn't know the midwife's position as to what time the lab.
But you knew what your client's position was. How about you verify that? It would have been that simple. But we've got your brief. Thank you so much.
Okay, thank you, Your Honor.
State of New York versus Andress A. You may proceed.
May it please the court, my name is Naomi Weinstein and I represent Appellant Andress A in this appeal. Your Honors, with my limited time, I would like to focus on the second part of Mr. A's argument, that the state failed to prove by clear and convincing evidence that Mr. A is a dangerous sex offender requiring confinement. In fact, what the evidence did show is that Mr. A does not have an inability to control his sex offending behavior. He participated in sex offender treatment while in prison. He voluntarily chose to continue that treatment in the custody of OMH after this Article 10 petition was filed. He's been medication compliant.
But that's what, yeah, he is in custody, which is why he's medication compliant. That is the problem, that when he is not in custody, he falls off his medication, decompensates, and attacks women.
So, Your Honor, I'm not excusing Mr. A's past criminal behavior or his behavior in the community. However, as Dr. Fraser, Mr. A's expert, credibly testified, and as the state's own expert admitted, cyst itself is different than what he had been subject to. He cannot go back to a shelter like he had been before with no supervision. Cyst itself is a protective measure against
Was
risk.
that was that an option for the court? Was the court under the statute permitted to have him go into a cyst program? I mean, it seems like maybe the statute has to be changed, but I don't think that was an option for the court to order that.
So when I think, Your Honor, if I could just, to answer your question, I believe that there might have been some confusion with the court as to what Mr. A's expert was recommending. What Mr. A's expert was recommending was community-based supportive housing, which the state's own expert testified does exist specifically in the world
Yes,
of
but he needs something much stricter than just community-based. I mean, come on. Every time he has been let out within months, he attacks someone else, okay? So he clearly needs strict supervision.
And that's correct, Your Honor, and that is what is available. CYST itself is very, as this court has stated in Enrique T, is very restrictive. It's not the same as probation or parole. He would be subject to 76 conditions that can be specifically tailored. And where the trial court erred is that the trial court had a responsibility per 1007F to consider the conditions of CYST. And when the state, like here, fails to prove that Mr. A has an inability to control sex offending behavior, which means there has to be some evidence that he's...
But they did present evidence that the state's experts did say he has an issue with impulsivity, with his ability to control his sexual desires and how he acts upon them, right?
The state
did say that. The expert did establish that.
The state's expert was testifying primarily on the underlying facts of the crime, which, as the Court of Appeals said in Donald D.D., the underlying facts of crime or crimes itself cannot form the basis. What the court has further clarified... I'm sorry.
I'm sorry. I was under the impression that it wasn't the underlying crimes, but the very disabilities that were confronted with.
Precisely.
He had an IQ of 50, I think.
Of 50?
And 50?
55, Your Honor.
Okay. So, and it was a combination of that and his poor impulse control, all those factors that created a real problem for him outside, correct?
So respectfully, Your Honor, his intellectual disability and his diagnoses, that goes to the first prong of mental abnormality, which we're also arguing the state failed to prove by clear and convincing evidence. But what the appellate court and the Court of Appeals has further clarified is that in order to show the higher level of inability, to prove that second prong, which is the focus of my argument before you today, they have to show that he's presently unable, and that comes from George N., that he's presently unable. And as Mr. A's expert credibly testified to, even when he's incarcerated, you would expect to see some sort of proxy behavior, some sort of misbehavior. Mr. A has not had any disciplinary tickets. He has never acted out sexually whatsoever since the incident.
But isn't it a fact that he acts out in front of young children, not necessarily in front of older adults?
That's true that the victims in this case were an age range of 8 to 15. However, as Dr. Fraser, who has extensive experience working with sex offenders, both who have intellectual disabilities and mental illness, she explained what proxy behavior you would see and what she does see in her work, which is that even when there's not maybe children or adolescents, you see behavior like grooming behavior. You see an attempt to
But
watch
there's
TV
no
with
one
children.
to groom. So again, these observations are really difficult because they are in this very structured environment, right? So we're not evaluating these individuals in the community where you'd like us to place him, right? It's a different assessment. And again, based on Dennis K., it seems to me that the state put forward sufficient basis for 2 different diagnoses of your client that would suffice to establish his dangerousness and the propriety of civil commitment. I'll let you respond.
Thank you, Your Honor. I see my time is up. I would just respond respectfully, Your Honor. Dennis K. goes to the mental abnormality, which is the first prong that the state has to prove, and does not speak to whether he has an inability to control his sex offending behavior.
Oh, but
Insist
no,
is meant-
Dennis K. talks about all of it. It doesn't just talk about that. It lays out what are the criteria. It can't just be
ASPD.
ASPD. It has to have an additional finding, but then they go on to discuss the other issues. So it doesn't just talk about that, but I'll let you talk about that when you get back, and I'll give you a little extra time. All right? I'll hear you.
Good afternoon, and may it please the court. Anaga Sundarajan for the state of New York. Supreme Court correctly concluded that Andress A. suffers from a mental abnormality, and that based on the undisputed evidence at the dispositional hearing, concluded that Andress A. is a dangerous sex offender requiring confinement.
Now, perhaps I was a little confused in reading the record and the statutes, but what was the problem with the cyst regimen? The court did not have the right under the statute to require that. That seems to be like a little bit of an in-between place, not letting him out, but not having completely confined. So how do you get to the cyst program?
Sure, Your Honor. So a couple of responses to that. The first is getting there is part 2 of the court's inquiry. Here, there was ample evidence to support the court's conclusion that he met the requisite level of dangerousness and therefore under the statute required confinement. And I'll return to that in a moment. With respect to Your Honor's question, both the statute and the statute as interpreted in Nelson D. make very clear that it doesn't allow for that intermediate. You either have to have confinement in a secure setting under OMH custody or treatment on an outpatient basis under DOC's custody. We can't have Article 10 does not allow for that intermediate kind of confined, but not really, in large part because the purpose of Article 10 is not only to provide treatment, but also to ensure the security of the community for offenders who are unable to control their behavior and who meet that level of dangerousness.
So had this individual been in a residential treatment program, would he be entitled to cyst?
So to clarify, Your Honor, it is certainly possible that someone under Article 10 civil management who is out in the community on a cyst regimen can then be placed in a residential treatment program. The problem here, there are 2 problems here with what respondent's expert was asking the court to do. The first is, again, as we noted, he has already shown, the state has already carried its burden of showing that he meets a certain level of dangerousness and that he cannot be treated purely on an outpatient basis. Based on that evidence, the court correctly concluded that he meets that dangerousness threshold and so has to be placed in a secure facility. Additionally, what respondent's expert was asking for was a level of supervision that went above and beyond what is contemplated by SIST, and that is where we
But then
fall
what
into
you're
this.
saying- because what I'm hearing you say, though, and it's troubling, right? What I'm hearing you say is, in part because this gentleman has an IQ that prevents him from fully understanding that he has to take this medication or he's going to decompensate. Are we saying that he will never get out of confinement?
No, Your
How
Honor.
does he establish that he has gotten insight? I mean, how does he do that from behind these walls in this setting?
So a couple different ways, and I would point this court to Dr. Hernandez's testimony during the dispositional hearing. While in secure confinement, he has had access to treatment that is not only about sex offender treatment, but helping him develop pro-social behavior, helping him develop coping mechanisms, helping him develop ways to interrupt and self-regulate his behavior. Now, while in secure confinement, he has the right to petition at any time for review, which includes a petition to review his mental abnormality finding as well as his placement. He also has a right to an annual review. So it is certainly possible that a year from now at his annual review or at another time, because he has had access to this treatment that is tailored to his specific disabilities and is being provided while at Stark, that he will be able to show that he's developed some kind of coping mechanism, some kind of progress in treatment. The problem here is none of that has happened yet. He has, while he understands what his triggers are, he has not demonstrated any kind of mechanism to avoid them while in the community. And these are triggers as simple as avoiding children who are out on the street going about their business.
Now, I know counsel focuses on the fact that the state's experts really just touched upon, I should really say, focused on the facts of the underlying case. But, you know, I have the transcript here, and it seems to me that it was based on an entire psychological portrait when you're talking about the diagnosis, the intellectual disabilities, coupled with lack of insight, you know, substance abuse that lowers the inhibitions. No?
That's correct, Your Honor. And we would also note
And testing and assessments.
That's correct, Your Honor. And we would also note that there was testimony additionally about his performance on various risk assessments, about his lack of treatment, about his prior performance on supervision, which was very poor. And this testimony about these factors that went into the state's experts' conclusions were all, the respondents' experts agreed to the underlying facts, as Supreme Court noted in its opinion. Now, while respondents' expert may have reached a different conclusion, that different conclusion, again, was based on the court imposing this intermediate step or this intermediate kind of unsecure confinement that is not allowable under the statute. I'm happy to answer additional questions with the remainder of my time. If none-
So somebody who has this intellectual disability, that I agree with my my colleague Justice Mansonet Daniels. This is troubling because if he can't operate out in the community on his own by himself, then he's always going to need supervision. But would he be required to live in some type of residence because he can't medicate himself? He doesn't know how to read and write.
So again,
That has been his problem.
So again, we would point this court to Dr. Hernandez's testimony during the dispositional hearing, which contemplates the fact that with the kind of treatment that he is receiving at Stark, he may be able to develop strategies to deal with that, strategies to cope with his disability and develop techniques to actually succeed in the community. Again, he's not there yet. Additionally, to the extent that is a concern, that's something that he has the right to revisit.
Are you aware of any state facilities that would permit someone like him with his history? Because people in our society who have these mental deficiencies have supportive housing in the community. But often that is a mixed sex housing, which could be problematic here. So is there any state facility that would be able to house him, that would accept him into housing? Or again, because I continue to harp on this, because it would not be right that because of his mental deficiency, he spends the rest of his life in confinement.
I'm not sure about that, Your Honor, and the record here is silent as to that. And again, this is something that can and often is revisited at either the annual review or the petition. At this stage, it has to be a secure facility given his lack of insight, his lack of coping mechanisms, and his inability to control his behavior, which is well demonstrated by this record.
Thank you.
Thank you, Your Honors.
Give you an extra minute. Okay.
Thank you, Your Honor. I wanted to start by saying that SIST is meant to be the default. That is clear in the legislature intent in 1001 of the statute. And SIST is not meant to be a one-size-fits-all. And where the trial court erred is failing per 1007 to consider the specific conditions of that Mr. A would need, contrary to what.
But again, so it goes back. I'm going to ask you the same question, right? So is there a facility that would accept someone with your client's history, okay? So, because in residential placements where you have co-ed population, they're not going to, I can't imagine any center that would assume the liability of having someone with his sexual crime history.
So respectfully, Your Honor, absolutely. It doesn't necessarily have to be a state-run facility, but as this court is aware from its appeal in Anthony R., Mr. R was living in a supportive residence that exists through OMH that the state's own expert, Dr. Hernandez, testifies does exist. So I understand that it could be problematic, but unfortunately there are people with intellectual disability and mental illness who do get entangled with the criminal, justice system, but that doesn't mean that he has an inability to control his behavior. What the record demonstrated is that he actually has made progress. He does understand the importance of staying away from substances, of staying away from children. He's able to follow directions, and Dr. Fraser credibly testified, and Dr. Hernandez agreed that he's never been subject to GPS monitoring. He's never been subject to scram monitoring that would monitor alcohol use. He's never had, the court could, for example, direct the level of housing that he would need. He's never had that he's been discharged to a shelter before. He could have, for example, a forensic case manager who could help him navigate the world because, as this court noted, it is difficult with his IQ and he's Spanish speaking only, and he's not able to read and write. So there are accommodations that need to be made in order for him to be on SIST, but that does not make him a dangerous sex offender who requires confinement. Thank you.
Thank you so much. Thank you both. Nanith versus 590 Madison Avenue. You may proceed.
Thank you, Your Honor. May it please the court, Matthew Cuter for the appellant's Eclipse Contracting. My argument here is fairly straightforward. There are 4 causes of action in a third-party complaint against my client: contribution, common law indemnity, contractual indemnity, and breach of contract for an alleged failure to comply with obligation to obtain insurance. The common thread between all 4 of those causes of action is showing that my client's acts or omissions allegedly caused or contributed to the alleged accident. Nobody on this record claims that my client's acts or omissions contributed to the alleged accident. I submitted a very thorough expert affidavit explaining why my client's conduct did not cause or contribute to the accident. Nobody rebutted my client's material findings. Plaintiff's expert only disagreed with one finding with respect to the weight of the materials on the cart, but that disagreement is not material because the highest estimate of the weight is 800 pounds, and it's undisputed that the cart could carry safely 3,000 pounds. Third-party plaintiff's expert does not dispute a single finding of my expert. The only time that he mentions my expert report, he comments on it favorably. I was not honestly expecting questions by this point in time.
I was going to have a question for you.
There you go.
So if you're saying that there was no negligence on the part of your client because the cart could hold 3,000 pounds and the sheet metal that was on it was about 800, so then everything was good.
Yes, sir. Not just that. My expert affidavit, in detail explains that the weight of those materials on the cart was centered on the cart. The cart was designed and marketed for materials such as that. The center of gravity of the materials in cart system was less than halfway up the height, which is appropriate and it's a stable condition.
The only problem that we have is that the cart actually flipped, and the sheet metal actually fell on somebody.
Your Honor, Your Honor, plaintiff pulled the cart onto himself. That is correct. Plaintiff's
what?
expert. I'm sorry?
Plaintiff what?
Plaintiff pulled the cart onto himself.
He pulled the cart onto himself.
Yes, Your Honor.
That's your theory, that he did this to himself on purpose.
No. I'm not trying to suggest he did it on purpose. He was moving the cart. The cart, plaintiff claims, got jammed on debris on the ground as he was trying to move the cart.
Well, according to you, the cart is perfectly fine to pull and move the weight that it had and the materials it had. So if it was perfectly fine, then it shouldn't have tipped over. So something went wrong. And according to the theory here is that there was debris on the floor, right? So then the question is, whose responsibility was it to keep debris from the floor?
It was the general.
Is it your client's responsibility?
No, Your Honor, it was the general contractor's responsibility. And the specific piece of debris that plaintiff claims that the cart got stuck on was a piece of electrical conduit or pipe. My client is a carpentry trade. We were not the electrician. It was not our debris. And ultimate responsibility for clearing debris on this project site laid with the general contractor, not my client. We were not even working in that area. And frankly, we weren't even working on that floor on the date of the incident or for several days before that. I just want to talk more about, the issue with the cart falling onto a plaintiff. I do not mean to imply that plaintiff intended for the cart to fall on him. He was moving the cart, it got stuck on the debris allegedly, and it fell onto the plaintiff.
So if that's true, if the cart indeed got stuck on debris and then tipped over, how is he at fault for that?
It doesn't matter from my point of view whether or not plaintiff was solely proximate cause or not.
Well, no, you see, he can't be the sole proximate cause if the wheels of the equipment he was using that was supposed to provide safety, right, fails because it gets stuck on something and tips over.
I need to stress this point. Plaintiff was moving that cart for weeks before the incident.
I'm sorry? He was moving the cart, what?
Plaintiff was moving that cart for at least a week before the incident, maybe 2 weeks. His testimony is a little hard to follow. He testified that he had no problem moving that cart when the ground was clear. Plaintiff's own expert blames the debris as the proximate cause of the incident, not the cart itself. Plaintiff's expert does not fault a single aspect of that cart or the wire mesh. Plaintiff's expert blames the degree. Third-party plaintiff's expert blames the manner in which plaintiff was attempting to move the cart. Nobody blames the cart itself. Nobody blames my client. And that's why I believe,
And nobody blames the manner in which those sheet metal pieces were stacked.
Correct. Nobody blames the manner in which the sheet metal was stacked. Counsel tries to raise some issues about that, but the actual testimony is very clear.
Was there testimony that he was moving this because this was left in his way?
Plaintiff testified
That
that as he was moving along and as he was working, he saw that the carts were in his way.
He could not do the work unless he moved the cart. And there was no one available that had the cart to move it. So he had to move it to do his job.
The testimony with respect to my client's placement of the carts is undisputed. My client testified that in the weeks before the incident, they placed their carts in a storage area that was safely stored. Third-party plaintiffs, in their response to my statement of facts, acknowledged that my client stored their carts in appropriate locations, and they were not aware of any complaints about where my client stored their carts. And my witness, Noel Brady, specifically denied that we stored those carts in the area where the accident happened.
But that's
There
where
was
it happened.
no, I'm sorry?
That's where the card was.
But that's where it
That's
was.
what the-
But you'll have
Plain-
time on rebuttal.
Thank you, Your Honor.
May it please the court, my name is Dan Ratner. I'm representing the plaintiff on this appeal. The full story, well, first of all, the procedural posture of this appeal is a little odd because my client didn't sue Eclipse. The other parties moved for summary judgment. We moved for summary judgment. The court granted our gravity-related labor law claim, granted us summary judgment, denied the industrial code part. In any event, I think Eclipse is here because they want to say that it was either all my client's fault or it did nothing wrong. The full story is this. These wire mesh, A-frame carts containing very heavy wire mesh was originally apparently stored on this floor. Eclipse then did not appear on that floor. Apparently was working on a different floor. It had no protocol for inspecting its own equipment, which it was supposed to be taken care of, as a result of which somehow the carts were moved around. A deponent in the case from Eclipse, who has since died, told somebody, a non-testifying witness told someone who was deposed after the accident, oh yeah, plaintiff's employer was moving them around. But that's hearsay. It's just hearsay, right? There's no first person. In fact, the person from Eclipse who testified said they had no protocol. He does not know why they got there. He does remember where they were originally stored. In addition to that, we have debris, right? In addition to that, plaintiff testified that he had complained about these carts being in his way. He was a young guy, no one was listening to him, and he was under pressure to get the job done. So sure, he steps off the man lift to move it out of his way, and lo and behold, it falls on him. Another piece of evidence. Eclipse is maintaining that there's no dispute as to the manner in which these wire mesh sheets were placed on the A cart. I think that's a vast overstatement. The witness who testified was asked to look at a photograph at page 679. Looking at this photograph, can you identify what, if any, strap or binding or anything that was used to restrain the security metal to this cart? Well, I can't see offhand. He's looking at a photograph. It looks like there's a bolt or something in the middle, bolting the mesh to each other. I'm not an expert. There are photographs in the record. It's just not clear. And if you look at the photographs, they seem to be a little moved around. Maybe they weren't bolted tightly enough. I don't know. And certainly there's no strap on those photographs. So there's a dispute about that. So Eclipse is trying to sort of get out of this case on the contribution claim. That's why they're pointing fingers, I guess, in our direction. We say, no, we were properly granted because there was debris on the floor. It was in his way, and that really is every contractor's obligation, as well as the owner, to make sure a path is clear, to make sure its own equipment is not in the way. Simple as that. So that's our argument. There's
Seems
also
like it's premature, really, to let anybody out because the facts are not, the negligence, we're not sure. There's statutory liability and then there's other negligence.
I'll just say, Your Honor, we were properly granted summary
judgment on 240.
On the 240 claim. The other parties have not appealed. So Eclipse is here to argue that somehow or other that should be set aside, even though we didn't sue Eclipse. So I'm not sure how you got it. We've also argued, by the way, that the judge should have granted, and this court should grant our claim regarding the industrial code violations, because there's no dispute that there was debris in the way in violation of the industrial code.
Thank you.
Thank you.
May it please the court. My name is Jonathan Sellers. I represent respondents, third-party plaintiffs and defendants, 590 Madison Avenue, Shawmut Woodworking, and Turnow LLC.
Can I ask you one question? 590 was actually the owner of this premises, and they leased it to Tourneau, who then entered into a contract to have Shawmut be, were they the GC?
That's correct. Shawmut was the general contractor for this
Yeah,
project. Yep.
so they were the JC, but they had a contract with Tourneau, not with 590 Madison?
That's my understanding, Your Honor, yes.
So there is no contract between the actual owner, 590 Madison, and the GC, right?
I'd have to check I don't have the contract documents right in front of me, but that really, I mean, I believe you're correct that it was the tenant, which was Turnow, was the one that retained Shawmut, not Turnow. Obviously.
So that any recovery on the part of your client would have to come from your tenant, since you were not in privity with the GC.
Well, Your Honor, appellant made the lack of privity argument for the first time on appeal. That was not argued in the trial court level. There was no argument whatsoever about 590 Madison and Turnow not being in privity of contract with Eclipse. As Your Honor knows, that it's improper to raise an argument for the first time on appeal because the trial court obviously didn't have a chance to review those arguments and weigh in and give a decision. So, while that might be a point, it'd be improper to rule on that point since the trial court wasn't given that opportunity.
Well, is it something that we can look and decide just from the face of the record? Because even when not raised below, when that is the case, this court can still make a determination.
Well,
it was something that was clear on the record and should have been argued by someone. Why can't we dispense with an issue that is obvious?
Well, so the subcontract agreement with Eclipse, so there was the universal subcontract that was entered back in 2009 that was intended to govern all of the various jobs that that Shawmut would retain Eclipse for various jobs. They do numerous jobs over the years. This particular job for Turnow took place in 2020, and the job order itself incorporated the universal subcontract. Express language could be more clear on the first page. It states the contract number and the date that the 2009 contract was executed. So there's no question about it being incorporated into that. And the insurance obligations and the indemnity provisions of the universal subcontract include the obligation that Eclipse to indemnify not just Shawmut, but also the owner's entities and stuff. And so, and
what do we do with the fact that there's a lot of documents that refers to the owner as Tourneau and not 590 Madison?
I believe if you look at the job order, Your Honor, for the...
I mean, it isn't just one document, it's a few.
Right, so it's... The job order for the specific job had several riders to it, and throughout those riders, it identifies Turnow on there. And if you also look there, rider A is the actual design drawings, and those have listed 590 and Turnow. And there's times where 590 is also listed as, and Turnow both listed as owners interchangeably because of the role of being property owner and landlord. So they're being referred to, identify both as owners, even though technically it was only the actual property owner, so to speak.
Thank you.
Thank you, Your Honor.
All right. You have 2 minutes.
I'll try to be very quick.
You got 2 minutes.
I know.
Okay.
So plaintiff's counsel suggested that perhaps the wire mesh wasn't bolted tightly enough to the cart. In the underlying motion practice, plaintiff counsel admitted in their response to statement of facts that the wire mesh had bolting to hold it in place. With respect to plaintiff's argument that Mr. Niante made complaints about the location of carts, on every occasion where he mentioned it to the general contractor, his response, they were addressed and the carts were moved for him. On this particular occasion, plaintiff chose not to ask anyone to move the carts for him.
There was no one there to ask. That was his testimony.
There was no one there.
So was he supposed to leave the floor, stop doing his job, leave the floor, go find one of your guys to move your stuff?
He didn't have to find one of my guys. He could have found one of my guys or one of the general contractor's guys. He could have asked somebody.
So that's really what you expected him to do?
Yes,
That it
Your
was his job to go find one of your people so he could keep on doing his work? That just belies the realities of construction work. It just does.
Okay, Your Honor, plaintiff admitted that the procedure for this project for moving other people's carts was to either find the owner of the cart or find the general contractor and ask them to move the cart for you. But I'm just want to move
We
on.
also have Mr. Fitzgerald's testimony. I believe he's from Eclipse, that he said, you know, if you're moving an A-frame cart with the heavy metal and there's debris, that could cause the cart to tip over.
The debris could cause the cart to tip over, not the condition of the cart itself.
You keep on focusing on that as though that helps you.
I believe it does, Your Honor, because the debris is a general ordinary hazard on the ground. It's not an elevation-related hazard as provided in the Nicometti line of cases.
Right. Thank you. Thank you so much. Connect One Bank versus Legacy Builders. You may proceed.
Good afternoon. My name is Preston Postlethwaite. I'm here on behalf of the defendants, appellants, Legacy Builders, and John Bernardo. We're asking this court to reverse the decision granting summary judgment to Connect One below.
Well, we know on this record that essentially, colloquially, the paper trail underlying the note was substantiated by an affidavit of an officer with personal knowledge of the paper trail.
Yes, Your Honor, that's
Fair
Mr.
enough.
Minardi.
And there was nothing from your side of the table below to really counter any of that.
Unfortunately, that's correct, Your Honor. Yes, there were.
Okay, so now you're here appealing the grant of summary judgment and the failure to grant your, and because you claim you needed discovery to be able to support your conclusory affirmative offenses that were all dismissed, correct?
That was an argument that was raised below in the opposition to the motion for summary judgment. Obviously,
Well, you didn't appeal the denial of the cross motion, correct?
that's correct, Your Honor. Yes, we did not appeal the denial of the cross motion.
So why are we here?
Our appeals focus squarely on the failure of Connect One to make the prima facie case on the cause of action, the first cause of action for breach of the loan documents.
Which you basically said was undisputed because no one countered what they had to say.
Well, Your Honor.
I'm sorry, I apologize. You're talking about the defaults.
Yes, Your Honor, that's correct.
The 11.0G, which talks about not only monetary defaults, but defaults in allowing certain liens to be incurred, correct?
Correct, yes, that's right. That's the
And
allegation.
you agree that a fair interpretation of that particular section mandates that there can be a default not only of monetary defaults, because you didn't even make the first payment under the loan, correct?
Incorrect, Your Honor, that's not right. So.
Oh, you made the April 2023 payment?
That was the first principal payment, Your Honor. And this is something that I think was glossed over below. The loan documentation and the agreement, the four pieces constituting the loan agreement, that was executed April 19th, 2022. It called for monthly interest payments for 83 consecutive months. All those were made up until March 28th, 2023, when Connect One noticed us for a default based on our failure to disclose certain issues or potential liens that would be incurred by virtue of some litigation going on with a third party.
Yes, slight little problem with judgments for $9 million and nine. Come on.
A huge problem.
You were required to notify them of those liens, and you didn't.
Your Honor.
That is a default under the contract language.
I apologize for interrupting, Your Honor, but if you look at the documentation, the loan documents require the appellants to advise Connect One of the existence or threat of any substantial litigation that may impair the defendants from being able to repay the loan. That's right. And in the documentation, in the schedules to the loan documents that were executed April 19th, 2022, we disclosed these three potential issues. affirmatively. We did what we should have done. We didn't hide anything.
But isn't there also a clause in the document that says that if there's a judgment in the amount of $100,000 or more that is outstanding for more than 30 days without being satisfied, that's also a default?
Yes, that could give rise to an event of default. That's exactly right. Yes, that's
So
correct.
now you have 3 judgments in the amounts of $16 million, $9 million, and I believe another $5 million. And they're there. They're judgments against your client, and they haven't been satisfied.
If I may, Your Honor, they're not there. There's nothing in the record to show that these judgments exist in the first place. That's precisely the problem. There's nothing in here. And it's not my client's job to disprove that which may or may not exist. It's Connect One's responsibility to show, listen, these are these massive judgments and liens that were levied against the debtor, okay? This is a problem, and we're going to declare an event of default, and we're going to accelerate the note, okay? Well, below, Connect One didn't do that at all. They're the only mention of the existence of these liens and issues, the only mention is in the notice of default where, quote, borrower advised us that these existed. Where are they? Go to the UCC platform and download copies of these liens if they're for $16 million. What's going on here, number one? Number two, borrower advised the bank that these liens were entered. Huh? What borrower would do that? I mean, of course they have to do that, but it makes no sense. And number three, below, they had the opportunity to do so because that's what they sought. Why don't you have somebody who actually spoke to someone from the borrower, from my clients, over dinner, a phone call, an email, to prove that indeed somebody did advise the bank that we had these issues? There's nothing there. The only mention of it is hearsay, which in of itself is insufficient to support a prima facie case.
What about the affidavit of the principal of Connect One?
Mr. Minardi is a senior vice president, and he had, the record is silent as to his involvement with the creation of the loan documentation in the first place, which is to say, he wasn't a signatory to it, right? Number two.
Does he have to be?
He does not have to be a signatory to it, no, Your
If
Honor.
he's a part of the business and knows the business records and the deal, he can certainly.
That's correct, Your Honor. Yes, he's able to opine on the practices of Connect One in terms of how the loan was administered and payments and so on and so forth, right? But the crux of the issue is not the failure to make payments, okay? The crux of the issue is that apparently the bank was advised by the borrower that there were 3 huge judgments entered, okay? Who said that to whom? Not to Mr. Minardi. The affidavit is completely silent. No one spoke to Mr. Minardi.
Thank you.
Thank you.
Please, the court. James Kim on behalf of Connect One Bank. Your Honor, I think the record is very clear of the events of default in this case, both in the nature of non-monetary and monetary natures.
Why don't you address his last point that there is no proof of the actual judgments?
Your Honor, no proof is required. We were told by the borrower
Wait a minute.
directly.
Someone tells you there's a judgment and you don't have to go look them up, document them in order, no?
No, they made an admission to us that the judgments were there, so we sent a notice of default advising of same, and they never responded to the letter.
Who admitted to the judgments?
It was, my understanding, it was one of the officers of Legacy Builders. But
That seems really, really vague. I mean, counsel, you were granted summary judgment, right?
Yes.
So that has to be based on some evidence.
yes, the evidence.
So
was
what
an
is the
admission.
evidence?
The evidence was that simply.
Somebody told me? Who's the somebody?
It was an officer of Legacy Builders.
Which officer?
I don't know. I don't know.
Counsel, how is that adequate evidence?
Judge,
How is that adequate?
But Your Honor, you don't. It was a notice of default that was based on an admission by the borrower to a lender. But Your Honor, I think the one thing that is being
Have they
blown out of
acknowledged
proportion
that?
is.
Have they acknowledged that admission?
Well, they never refuted, Your Honor. They never responded to our default notice. They're pointing the finger at Connect One for not proving the default. This is not a trial on the default. Lenders issue notice of the default based on admissions, based on what they're hearing from third parties, based on what the borrower discloses, based on the fact that a payment doesn't come in. That's exactly what happened here. Our complaint addresses those disclosures and addresses the fact that payments did not come in. At no point in time did the borrower send a letter in response to the default notice saying, no, you are wrong. They never submitted an affidavit in response to our summary judgment motion saying, no, we have issues with the non-monetary defaults. And oh, by the way, we also have issues with the monetary defaults. As we sit here today, Your Honor, 2 years has gone by, not one single payment has come in.
So they didn't make that $400,000
No payments
payment
have
in
come
April of 2023 as required.
And our
under
summary
law.
judgment motion was not purely based on just non-monetary defaults.
And putting aside that we don't have the kind of proof to, with the exception of not denying the judgment, they do concede that there were investigations leading to these three judgments.
Absolutely, absolutely. In fact, in their brief,
which they claim is somehow notice.
Maybe. But the fact is, the entry of a lien or a judgment actually becomes a non-monetary default. But again, our summary judgment wasn't purely just solely based on a non-monetary default. It was based on the non-monetary defaults, and there were 3 of them, and it was also based on non-payment of the April payment, May, June, July, and by the time we got to summary judgment, all those issues were addressed with the court, and they never submitted an affidavit or a certification addressing any of those points, both non-monetary or monetary nature. And again, as we sit here today, none of those have been addressed.
And so we're clear also that there was no evidentiary foundation of any kind or factual support for any of the 11 affirmative defenses.
No, nothing was submitted, and the trial court properly accepted the Neil Minardi affidavit, considered both the non-monetary and monetary defaults, and based on the record, with no genuine issues of material fact, we respectfully submit that the trial court got it right and properly granted summary judgment in favor of the lender. Thank you.
Thank you.
May it please the court. It was not my client's burden to proactively defend against a prima facie showing of entitlement to summary judgment on a breach of contract claim, not a 3213.
But it's the 3212 motion, which has a comparable standard to 30, just bear with me, pre-answer 3213, but okay. And also keep in mind that your sole opposition below was an unverified answer with conclusory affirmative defenses. That was your opposition to a sworn affidavit by somebody with personal knowledge as to the various breaches, both monetary and non-monetary defaults, correct?
Yes, Your Honor, that's unfortunately the case. And there were mistakes made below. There's no question about that. But I think that the mistake in question here, which is the basis of why the decision and order should be reversed, is it was not our burden to show prima facie an entitlement to summary judgment on a breach of contract claim, which is what the first cause of action is. It was Connect One's burden. They had the ability to source all evidence of these liens and these judgments. They had the ability to source somebody at the bank who spoke
Thank
to
you.
somebody.
We've heard this already, and you're out of time. Thank you so much. Landa versus Freriedman. You have 5 minutes.
Good afternoon, Your Honors. May it please the court, Kyle Kunst for appellant and defendant Alexander Freriedman. Your Honors, the trial court erred when it quashed the subpoena to E-Trade. This subpoena was sent to support a long-standing defense of lack of standing that Mr. Freriedman had been basically screaming about since this case was first filed. Now, this case was first filed on a motion for summary judgment in lieu of a complaint. Your Honors, it was denied. Your Honors affirmed that holding. But the very first filing in opposition among them was Mr. Freriedman's affidavit, where he notes that there was certain evidence from the underlying matrimonial record we were unable to attend and file an opposition to that motion. Among those pieces of evidence was Mr. Landa's 2019 deposition transcript. Mr. Freriedman stated in his affidavit that Mr. Landa testified at that point that in 2016, this very trust that is supposedly enforcing these notes dissolved in 2016 upon the death of the grantor. Specifically, quote, my mother passed away and she had the irrevocable trust, which was dissolved. These are Mr. Landa's statements from his own deposition
And he's
testimony.
been trying to work back from that statement for the past 9 years, right?
He has, Your Honor. And I'm going to get us specifically to this E-Trade document. We deposed Leon Landa, who is the co-trustee of this trust, in early 2023. We asked him, what accounts do you have? What assets does this have? He said, we have this E-Trade account. What's in it? Over objection from counsel, he said, nothing. Like, okay, you've got no assets, you've got this empty account, E-Trade doesn't matter right now. We get to a 2023 status conference, and this is really kind of striking. This 2023 status conference is one of the first times, at least in this record, that the trial court below not only identified this disillusion argument we've been making, the trial court ordered the trust to produce documents regarding the dissolution itself. So fast
And what did you get? You got highly redacted documents that didn't really answer the question?
Exactly. We received a screenshot of an E-Trade statement. This is at record 50 to 51. We received this in mid-July of 2023, about 45 days before discovery is to close. The account number is redacted, the amounts are redacted, the positions are redacted. And so our position is, well, this is empty. We were told by Leon this is empty. Remove these redactions and show us that this is an empty account.
But even before that, there was a Jackson affidavit that was submitted, and then once there was an objection about that,
yes,
that is when that heavily redacted E-Trade page was then produced to show, yes, the trust is still in existence.
Justice Kennedy, you're 100% correct. This production of this E-Trade account was in tandem with production of tax records. Because again, we were asking for tax records. Show us that you've even filed taxes since tax year 2016 when you testified that this trust has been dissolved.
And you never got tax records for just for 2016 and 2017, I think?
Tax years 2015 and 2016. This is after we received the Jackson affidavit that Justice Kennedy alluded to, where the statement was, well, in answer to the question of whether or not we filed taxes since 2016, the answer is yes. Our response is, this is cagey, this is very strange. Another court order comes. We receive a letter from counsel saying, well, we don't have responsive documents. No taxes filed since 2006, tax year 2016. Going back to this E-Trade account.
You got about 20 seconds left.
I'll be very brief. End of August, about a week before discovery is to close, we receive a letter produced by the trust, a letter from E-Trade. The letter from E-Trade says, well, this account is still in good standing, but for the first time, the last 4 digits of this account are visible to us. Lo and behold, this account by number is the exact same account that's listed in Mr. Landa's personal trust as one of his assets, as one that he has inherited from his mother's trust, consistent with his 2019 testimony and inconsistent with the story he's telling now.
Thank you. May proceed.
Good afternoon. May it please the court. Jason Zakai of Heller PC for plaintiff respondent. Mark Landa as trustee for the Golden Landa Trust. Your Honors, the trial court properly quashed the subpoena to the Trust E-Trade securities account. There is no reason to disturb the discretionary determination of the trial court.
Unless it's been exercised in an improvident manner.
And it was not improvident, Your Honor. The financial records of the
Well,
trust.
The thing is, the judge has ordered these records to be produced from your client for some time, and they've gotten very heavily redacted documents, and they've gotten answers that there are no documents. Aren't these relevant?
No, Your Honor, they're entirely irrelevant. If you look at the status conference order on page 118 of the record of the appendix, the trial court said produce documents related to whether there were tax returns filed or not whether the actual tax returns themselves. And we did produce tax
Counsel, the
records.
whole point, okay, of requiring answers to these questions is so that they can get to the heart of the matter. And so trying to obfuscate that gets us nowhere and doesn't advance the ball in terms of getting to the end of this case.
We're not trying to obfuscate at all.
Apparently you are, because of course this is relevant. Of course it's relevant.
Disagree, Your Honor, and
So if it was irrelevant, why did the court, and I believe it was in the compliance order of May 2023, to also say, the Jackson affidavit should also discuss whether or not the trust has been dissolved?
It said if there are records on whether it's been dissolved or not, including as to whether tax returns are filed, which we did, and the trial court said, okay, this has gone on long enough.
But there was
You
no
don't
way
need
to verify.
Sorry?
There was no real way to verify when you give documents that you cannot verify, you can't identify.
Your Honor, appellant has said that there's no question. He believes there's no question that the trust has been dissolved. In fact, he made a motion for summary judgment that there's no issue of fact. He has all the discovery he needed because the assets, all this 10 years worth of history of the assets are not going to prove or disprove whether the trust is dissolved or not. In fact, the notes themselves that we're trying to enforce are assets of the trust. They don't dispute that principle in our brief. They are the assets. So even if that were true as a matter of law, and it's not, that you look to the trust instrument itself that says,
How would you have standing to bring this action to recover notes from the trust if there is no trust?
the trust still exists. If you look at the trust instrument itself, page 97 in the appendix, it says, the trustee's powers, including to enforce promissory notes, shall continue until there's a final distribution of the estate. Your Honor, the trust can't make a final distribution until they collect on the notes. That's what we're here for. And so what the trial court is considering the merits of whether it is a gift or not. That's besides the point. There hasn't been a final distribution. He's trying to look into 10 years, the account balances, the positions. He says on page 3 of his opening brief, the amount of the E-Trade account doesn't even matter. It's inconsequential. He admits that it's irrelevant. He's just fishing to try to prove a negative and ascertain the existence of evidence.
You think it's irrelevant that the trust account that is supposed to be a part of this, of Landa's irrevocable trust, is the same account number in her son's account? You don't think that that's relevant?
What the son got an inheritance after his mother died. That doesn't mean that the account, that the trust, boom, poof.
So the two trusts have the same asset, is what you're saying?
No.
Yes, because either Landa's trust still exists, and it has to have an asset, right, in order for it to still exist.
Well, it doesn't have to have an asset, but the assets are the notes that they're trying to enforce. And just because Mark Landa has his own personal trust and he got an inheritance, or just finish the sentence, he got an inheritance, that doesn't mean, it doesn't talk about the co-trustee and what the co-trustee got, his brother, what his brother got, and what happens to the existence corpus of the trust. In any event, it's overbroad. Thank you very much.
You have 1 minute.
I'll be very brief. The only two assets that have been identified are this E-Trade statement. I think we've beaten that to death. The other asset is claimed to be the notes, and they claim we dispute whether or not that's an asset of the trust, and we obviously dispute it's an asset of the trust. And again, it's based upon Mr. Landa's own 2019 testimony, where he says, he's asked who's enforcing these notes. The question is, who's enforcing them if the trust no longer exists? A, myself and my brother. He testified that they're individually enforcing these notes, not the trust themselves. They're not an asset of the trust. Thank you for your time, Your Honors, unless there's further questions.
Mandor versus Rafalski.
Good afternoon, Your Honors. This is an appeal from an order that dismissed my client's case at the pleading stage on a 3211 motion. And this case presents an egregious example of an attorney taking advantage of his client.
Would you agree that the original development agreement has very clear language that Mr. Rafalski's duties were contractual duties were to help develop the property, and if he did so and met certain target expectations, he would be entitled to certain types of benefit?
It does say that in the agreement.
And would you also agree that there's clear and an unambiguous language that whatever duties he was doing there in this development contract with Mr. Stein or with 10-3 excluded legal services? There's clear language in that agreement, correct?
That disclaimer appears in the agreement, and that type of disclaimer needs to be given to the client ahead of time, not in the agreement itself.
So you're saying it's not valid?
I'm sorry?
So you're saying it's not valid?
I'm saying it's not valid. I'm saying that this agreement on its face is not fair and reasonable to the client. He awarded himself 10% of his client's net income for life.
For life or for 15 years?
No, the 15 years was if he were to die before he had received 15 years of payments, payments would continue to be made to his estate until there had been at least 15 years of payments.
For 15 years?
15 years.
So it was not life, it was 15 years.
Well, he's alive, and he's continuing to get payments for life. So it's not limited to 15 years at all.
Well,
there's nothing in this record to indicate that he actually performed any development services.
So that's a good point, counsel. So you would agree if he never performed, how could you possibly have continuous legal representation to be an exception or toll what is so clear here as an action in 2022 beyond the 6-year statute of limitations, both for the development agreement, both for the shareholders agreement? I mean, it's so clear on this record. How do you get around all that?
The continuous representation refers to his activities as an attorney, and it's undisputed that he was an attorney before this development agreement was entered into.
But if you said he did nothing under the agreement, he was not providing any services. And the language of the agreement was clear that he was supposed to provide development services, not legal services.
Well, Your Honor, the one thing we know that he did do with respect to the development, because it's actually documented in the record, is he acted as the attorney for the company in negotiating a capital contribution agreement with the people who actually developed the property. So, one hand he's saying, I'm not performing legal services, and then he clearly is performing legal services. Since that time, he's continued to perform, we believe, legal services for the company. Certainly on this record, the court was bound to accept the allegations that are in the pleadings as true. It's a 3211 motion. He explains away those
But I'm sorry, I don't mean to cut you off, but while you're bound to deem the pleadings as true, when someone asserts a statute of limitations defense, then the burden shifts based on our case law that requires you to show factually why the statute of limitations is either told or still running. Do you agree with that law?
Well, in Faison versus Lewis, which is a Court of Appeals case on this, Your Honor, it says on a CPLR 3211A5 motion, which is statute of limitations, the court is bound to accept the allegations of the pleadings as true. And the only thing that was done here to refute that was an affidavit from Mr. Rafalski, in which he said, oh, you know, the continuing activities that I did, I wasn't doing those as a lawyer, I was doing it as a manager. So when I negotiated a lease on behalf of the company, I was doing that as a layperson, not as a lawyer, even though I'm a lawyer.
So how do we? You can't step outside of your body when you're a lawyer, right? And you can actually fulfill two separate roles, one being a lawyer and one being something else. So you say that as though this is an impossibility. It's not impossible.
Well, but for
So
the client,
really, we have to look at the facts here.
for the client, I don't know if he has different colored baseball caps, but it's not clear to the client what capacity he's acting in, and he continued to be a attorney for this company for many, many years.
So, counsel, how do we, deal with the fact that the development agreement specifically says this agreement shall not include the provision of legal services, and in the first and second causes of action, it is alleged that it was an improper business, arrangement.
We think that that's a self-serving provision that was put in there, and that it's clear from the
But
record.
your client signed it, right? And you are bound by what you signed. This is not. Come on.
Well, the client was.
This is not an unsophisticated party.
The client was never advised to seek
This
independent.
is not an unsophisticated party. He's been doing business for years.
Sophisticated.
So you'll have time on rebuttal.
Thank you, Your Honor.
May it please the court, my name is David Pohl. I represent the defendant, Tom Rafalski, and his entity, TRRKY. This is an action that seeks to invalidate an agreement that has been in place since 2003, has governed a perfectly successful relationship. That whole time, everyone has performed pursuant to it. The company has paid Mr. Rafalski month after month after month, amounts that, yes, total $1 million. My opposing counsel makes it sound like Mr. Rafalski just took $1 million. If you do the math, it's an average of about $5,000 a month over 15 years of work during the development of this property. Everyone has
Wasn't the development completed over in 2014?
It was, Your
So
Honor.
what's he doing? And didn't they get somebody else to develop the company? I mean, he didn't actually develop the company. He got somebody to develop the company.
Mr. Rafalski's job was to come up with the plan, put it in place, execute upon it. Yes, he doesn't go into facilities.
He's not
and build
pounding the
things.
doors. I got
Correct.
it. But what's he been doing since 2014, since it's been finished being developed? What kind of work is he doing now?
He manages. He manages 10-3. So Mr. Rafalski, he's pretty old now, so he's phasing out. But he, to this day, still continues to serve as a manager of this property. So, the development agreement itself actually doesn't even require that. The development agreement entitles him to 10% of revenues for life. That's true. Everyone should remember, from 2003 to 2007, Mr. Rafalski was working with no pay. That was the risk he took in a contingency agreement. We all know what contingency agreements are as lawyers. Sometimes you don't make anything. That's the risk he took. For 4 years, he didn't make a penny. Then his work paid off in 2007. Property starts making money, and Tom got 10% of revenues. Just as everybody agreed, for the next 15 years, the only person, nobody at this company ever contested this. Everyone's fine with it. Everything was fine.
I'm sorry, was one of the issues the shareholder agreement between the brothers and Mr. Stein, where Ms. Mandor was concerned that she wasn't getting a piece of the pie?
Well, that's true, and this gets to Ms. Mandor inherited through a trust a lifetime interest in a beneficial interest in a minority position in the company. That is the position that she used to then assert this derivative lawsuit, supposedly on behalf of the company, even though nobody who actually runs the company agrees with it. They're all being sued by her. She has asserted this interest to undo an agreement that her husband made now 22 years ago, because it reduces the amount that she gets on her beneficial interest.
So, but we're still left with this, that the court basically found that the statute of limitations bars this action in toto, correct?
Correct, Your Honor.
And the case law is clear that in order to defeat a statute of limitation defense, you have to somehow show some exception, some tolling, correct?
Correct, Your Honor.
And none of that is on this record, correct?
That's correct, Your Honor. And I do believe that we are here, appellant's initial brief, we're here because the appellant, with all respect, has misunderstood, misconstrued the applicable standard. This is not a 3211A7 motion where the court is required to accept as true all the non-conclusory, well-pled allegations. It's not that.
Right, it's A5, and A5 requires them to come back with facts.
Once the defendant meets the prima facie initial burden, which we did, of showing that these claims to invalidate a 20-year-old agreement were time-barred. Once we did that, which we did, burden shifts. They have to come forward with evidence that just raises an issue of fact. It's not the case, as they like to say, that the judge credited our whole argument and rejected all of theirs. The judge didn't do that. The court did it right. The court simply found that they had not raised an issue of fact that could support the continuous representation doctrine. They had to show that Tom Rafalski was counsel in 2003 on this agreement, despite everything the agreement says, and that he continued in that role all the way until April of 2016. The court correctly found that those documents did not show that. Thank you.
Thank you. You have 2 minutes.
I think the issues have been adequately covered in our brief. I'll waive my rebuttal time.
Thank you so much.
Thank you, Your
Have a
Honors.
good day.
Thanks.
Scalamandre Oliveria versus Juda Contracting.
Show and tell.
You may continue.
Good afternoon, Your Honors. Jason Smith on behalf of the appellant, Juda Contracting, Inc. Your Honor, we're here today to seek reversal of the trial court's judgment for the reason that it awarded delay, inefficiency, and crane costs that are outside the four corners of what the parties agreed to in their clear and unambiguous contract, and in doing so, resorted to extrinsic evidence to add to and vary the terms of that clear and unambiguous contract.
Is that because of the notice of claim condition proceeding here?
There's that, Your Honor. There's several issues. One has to do with Section 8 of the subcontract, which Your Honor just raised. That section has clear condition precedent language in it, required written notice with a statement describing what the claim was and the basis for that claim.
So even though there was notice, and I think everybody agrees there was notice, it wasn't exactly to the T the way the agreement provided for. Is that it?
Well, there's that, Your Honor, and then it's also the fact that it's untimely, and there's no dispute that the notice was untimely. But even just taking the issue that Your Honor raised, the issue of the notice itself, if you look at the record, the respondent's appendix, those letters, they don't contain the types of information one would expect to see in a claim notice, and the types of things that the First Department and the Court of Appeals have previously held are required in order to satisfy that notice requirement. The Universal case, which we've cited in our brief, in which several of the justices on this panel authored, specifically addressed that issue and said the fact of actual notice is not sufficient. The notice has to comply with the requirements of the contract, and it has to be timely. And in that case, the panel affirmed the dismissal of those claims. And there's a plethora of cases, and we've cited those in our brief. There's the MLB case that says the exact same thing. In fact, there was a case that was just issued by the First Department today that also addresses that issue, the Torkham Construction Corp. Versus City of New York, which is at index number 650262/15. That is an axiomatic principle of New York construction law. If there is a conditioned precedent in the contract for notice, and in this case, not just notice verification, you have to comply with that or you've waived your claims, and that's exactly what happened here. In addition to that, there is a no damages for delay clause in this contract. It's at Article 11. And as this court is well aware, no damages for delay clauses are common in construction contracts, and those types of exculpatory clauses are routinely upheld in New York. There is no basis, nor was there any finding by the Supreme Court that would allow for this court to, or the Supreme Court, to look beyond that exculpatory provision and award the types of damages that the respondent is seeking in this case. The types of conduct that were alleged and the types of conduct that the Supreme Court found are the types of things that the New York courts have previously said arise to inept management, poor project management, poor schedule review. In the Gottlieb case, in the JDL case, in all of the cases we cited, none of those rise to the level necessary in Coretta to either be unanticipated or to be gross negligence, bad faith, et cetera. The other issue, and the one that involves the courts looking outside the four corners of the document, has to do with the provision of a crane. And the allegation below was that somehow the risk of the necessary equipment to perform the work by the subcontractor shifted from the subcontractor onto the general contractor. But the subcontract is clear and unambiguous. The requirement on the part of Jude Law was to provide a single crane for the subcontractor's use, not exclusive use, just use. And
Well, you did provide it.
And we did.
The problem was that it was inadequate.
But again, Your Honor,
It really seems unfair, right? You get them to reduce their contract number by the cost of the crane because you say you're going to provide it. They need it for their work. And then everybody on the site is using it so that they end up having to get yet another crane in order to do their work. So that to me borders on bad faith.
well,
Because you knew what their work was. You knew what equipment they would need. And it was your company, not you personally, your client, who decides, I'm gonna pull this money back, I'm gonna save some money on the contract, and then this poor contracting company gets stuck. Millions. I mean, this happens again and again and again on these city contracts.
with respect, if I could address that. First of all, these are sophisticated business entities.
Yeah,
They know exactly what they're doing. In fact, if you look at the briefing from the subcontractor, what does the subcontractor say? We had just finished the 7 line. We knew exactly what was required for this project. They affirmed in sections 1 and 4 that they were aware of the site conditions. They'd investigated the site.
They were
looked
aware
at the-
that they were gonna have use of that crane when they needed it?
They
They were aware of that?
There is no exclusivity requirement in the contract, Your Honor. If they needed the crane for a specific period of time, or there was some durational requirement, the sophisticated parties who executed this contract needed to put that into the agreement, and they didn't do that. Instead, what we get is a subcontractor who agrees they will have the use of a specific crane, and they in fact got the use of that crane. And the fact that they then volunteered to go and procure additional equipment to perform their work is not the responsibility of the
They were in
general
a
contractor.
catch-22, right? You either get the crane so I could do my job and stay on time, or get hit with other costs because I'm not doing my work on time. They were in a catch-22, and let's not pretend that they weren't.
Well,
That your contract language allows you to do that to these contract? Absolutely. On that we agree. But is it fair? Is it right?
well, with all due respect, Your Honor, fair. and
We know what that means, all due
know.
respect, so you could keep your all due respect.
I clerked.
Okay.
That's fair. The fairness of the contract that the parties entered into isn't before the court. What's before the court is what does the four corners of the contract these sophisticated entities entered into, and that's what the contract says. Thank you.
Your Honor hit it on the nose.
It may not be fair, unfortunately, though, he's correct on the contract language. The contract language is very clear, and there is a condition precedent, and your client doesn't.
My client did. My client, there's the only people who were saying there are no notice is him. There's no testimony, Your Honor, whatsoever from Judlow. There's not a letter from Judlow saying, you didn't give us notice. What is this? What are you doing here now with all these claims? There's not one communication. Our client got on the stand and said they waived formal notice.
How did they
Judd
do
Lau
that?
How
never-
did they do that?
How did they do that?
They said that like that this is our procedure, we're going to go ahead and do this. You can waive notice.
But doesn't the contract say that you can't waive notice? I mean,
No,
they
the
make it
contract
very
doesn't
difficult.
Say you can't waive notice. This contract, many times, Your Honor, this is what I do for a business. The contract,
Us
you can
too.
have a non.
Us too.
I'm sorry.
Okay.
I didn't mean it that way.
All right.
What I meant, Your Honor, is that you can have a provision, and many times clauses, contracts will have provisions that says that there can be a non-waiver.
Right.
And that no matter what happens out there, there isn't going to be a waiver. There's no testimony here in front of this court that Judd Lau didn't waive it. The fact of the matter is, Judd Lau had introduced testimony, and none of the people disputed the testimony of Mr. DeSimone, who was there at trial and testified they didn't require verification. They didn't require notice. The fact that they had notice was unquestionable. I mean, I just brought in this one exhibit. It is A153 in the record. This is just so emblematic of what went on out here. This is only 3 or 4 months into the project. Down at the bottom is this laundry list of written notices by my client to them of issues on the project.
So what are you supposed to do after you give them that document with all of those, with the list of items? Doesn't the contract require that you take another step?
Yes, and they did. Mr. DeSimone, and you'll find it in the record, submitted estimated damage amounts all through the.
That's the equitable adjustment.
That was the final one where he took it when he now understood exactly what had happened, and he submitted the request for equitable
But
adjustment.
doesn't the contract require you, within 10 days of the following, by the 10th of the month following you giving that notice, to have given a detailed notice and verified?
The fact of the matter is, Your Honor, that they waived that.
Well,
They waived that requirement.
this is my understanding. Section 8 says, and I won't get caught up with the time, unless such statements and data shall be delivered within the times aforesaid, all claims for such compensation shall be deemed waived. The way I read that, by operation of law, that clear contract language, that if you didn't meet the criteria within 2 calendar, et cetera, I'm not going to read the whole Section 8. I know you're familiar with it. If you didn't meet it and it's conceded you didn't meet it, then,
We don't agree we didn't meet it.
no, you gave different kinds of notices. The question,
But we also
you gave certain kinds of information to, I'm sorry.
During the course of the project, Your Honor, gave them notice of what we thought the damages were. That's all as part of the record. And there was never any request by Judd Lau that, okay, what you've given to us is inadequate. What you've given to us as to notice isn't enough.
But do they have to say that? Because the contract is very specific as to how the notice is supposed to be given.
I do believe they do it, Your Honor. If someone is, if you're a contract with somebody and they're not living up to it, I think you absolutely have a responsibility to say, hey, you're not living up to this contract.
But
You
the
need to
contract is
give me
specific.
notice. You're not giving me, they're getting all these notices. We're saying we have all these claims, we have all these claims. What they're coming in here and is asking for is basically, we can have all these claims, have all these issues, and the fact of the matter is, we've got to get out of jail free card because we never asked you for anything more. We never asked you for verification.
But what the contract says is that if you don't give notice in accordance with Section 8 of that contract, then those claims are waived, just like my colleague alluded to earlier.
And I agree, Your Honor, except for the fact that our position is, and it's unquestioned, that they waived that demand.
But that's not what the contract says.
How
The
does
contract says is that you waive.
I don't understand how they waived it.
They waived it by orally agreeing with Mr. DeSimone that they didn't have to do it. What they were doing was adequate. There is not anything in front of you, Your Honor, that says
But
you
this
didn't give us
says
proper
unless the
notice.
statements and data shall be delivered within the time aforesaid, all claims for such compensation shall be deemed waived. So even though it's what I prefaced it, that they knew a lot of the claims that you were making and that you had an open line of conversation throughout this project. If you didn't do it exactly like this, I mean, gosh, I don't know how anybody enters into these city contracts with, because I don't know how anyone ever gets paid because they're so restrictive on your end. Nonetheless, we've all been on a lot of these cases and it's very hard for you to win these.
Well, the situation here, Your Honor, is that the notice was unquestionably given. There's no question, notice was given.
But there
as
is
to-
a question because the other side is saying you didn't give notice.
But they-
And that you didn't give notice the way the contract required.
Then
So
why
you keep saying that they waived that. So tell me, what evidence is there that they waived it and that they could waive it under the contract?
The most positive
Does the
evidence is,
contract permit oral modifications or do all modifications have to be in writing?
the contract calls for modifications in writing.
Okay,
And-
so
but
then,
the-
so then, how is it possible that they waived it if you're saying he waived it by an oral statement? That violates the contract too. I don't see how we get around that.
But Your Honor, what I can't understand is how you cannot let them know you're not giving me proper notice. You can't go on and say, okay, you're not giving me verification, and then.
But you're
years
supposed to
later
know, because you have the contract, you're supposed to know how it is that notice is to be given.
Yes, I totally agree, Your Honor.
And
they
unless the
gave notice and
contract,
they
sa-
thought
unless
that
the
notice they
contract,
gave-
unless you can point to us, okay? Look, I feel for your client, okay? It's never nice to do work and expend money as a business person and then not get paid for it. So I understand, all right? But I'm stuck with the language I have in front of me, right? And unless this contract has other provisions that say that they are required to let you know if the notice is not adequate, then they don't have a contractual responsibility to do that. And that doesn't afford you a defense.
Your Honor, I believe it does.
All right.
Thank you.
We will consider.
Thank you, Your Honor.
I'll hear you you have a minute.
Thank you, Your Honor. Article 25, Your Honor noted it, and I'm sure the court's aware of it, but just so that there's no dispute. Article 25 of the subcontract, no provision of this agreement shall be changed or modified nor discharged except by an agreement in writing signed by both parties. And there's no evidence. There was no evidence below of any written waiver. There's no evidence here of any written waiver because it didn't happen. The evidence that was adduced at trials related specifically to T&M tickets and T&M tickets only. And there's case law. It's the MLB case and there's the Triborough tunnel case, negotiation of change orders, and even discussions about resolution of claims themselves are insufficient to rise to the level of waiver that would permit a party to get around the type of condition precedent we have in this subcontract. I'd also note that one of the two parties to this joint venture on the subcontractor's behalf is well aware of these notice requirements and the requirement for verification because they filed the exact same defense in Morelli Brothers versus Peter Scalamandre and Sons and successfully prevailed on the fact that the subcontractor there didn't provide timely written notice and didn't provide verification. Thank you, Your Honors.
Thank you. Sergio Sanchez versus 1649 Nelson. May
Good
proceed.
afternoon, Your Honors. May it please the Court. Beth Gehrig on behalf of Lesh and Lesh in the rare position here where Lesh and Lesh actually has a defendant today. We're asking for reversal of the trial court's decision. We moved for summary judgment based on the fact that a worn step without more is not an actionable defect. The trial court
What about
agreed.
the handrail?
Exactly. The trial court agreed with us, but said plaintiff's expert Krongelb talks about a handrail. The problem is the handrail has nothing to do with this case.
Well, the video makes that clear, correct?
I'm sorry?
The video, the nature of how the plaintiff fell, not at the landing, but he fell further down, reaching out while he was on his cell phone.
Absolutely.
So that makes the handrail absolutely irrelevant factor.
Absolutely, and he even testified to it. If anybody wants to say that the video is unclear, I think it's extremely clear, but he testified that where he slipped 1 to 2 steps down, there was a handrail immediately on his left-hand side. So if the court's going to say that you need more than just the worn step, here there was no more. Every single case cited by the plaintiff in their respondent's brief where they talk about a worn step actually had more. I don't want to waste the time because I think you understand my arguments, and I'd like to instead wait for a rebuttal. Thank you, Your Honors.
Good afternoon, Mike Briscoe for the respondent. Your Honors, this court should affirm denial of summary judgment because there was more. There was more than just a worn step. In this case, like a number of cases that we cite, not only was the step worn, it was misshapen and irregular. Photographic evidence in the record at page 576, when you look at that photograph, you could see with your own eyes just now how warped that step, the step that the plaintiff slipped on, is. Not only do we have photographic evidence to show that, an expert performed an on-site inspection. This wasn't an expert report based off of speculation. The expert went down to the stairs after the accident and inspected the step that the plaintiff testified he slipped on. He found not only visually with his eyes, as we can see in that photograph I referenced, that the step was irregular, he also confirmed it with measurement. Towards the center of the step, it was depressed by a ½ inch. And importantly, the nosing of the step was irregular by a ¼ inch. And I said that is important because we cite to a case, Carrion versus Faulkner, a 2016 case from the Court of Appeals. There, the plaintiff slipped and fell on a step that he claimed was worn. This court affirmed summary judgment to the defendant. The Court of Appeals reversed. The Court of Appeals reversed because the plaintiff testifying that he slipped on the edge of the step that was worn was more than just a worn step and created a triable issue of fact that needed to be resolved by a jury, not by the court as a matter of law.
See, part of your problem here is that we have a video, and the video is pretty clear that your client is not looking where he's going. He's got both hands on his cell phone, and he takes 1 step down and slips. By the time he tries to grab for the handrail, but his body's already below the handrail. So when he grabs for something, he's already past the handrail. So he's already falling. I don't see what you say is there. I mean, I saw the photograph. It's not the greatest step, but is that enough? Based on, between that and the video?
Based on the case law, yes, that issue and the debating of whether the step is an unreasonably dangerous condition must go to the jury based on the case law. Just like Faulkner, just like after Faulkner, this court decided a case in DePenn, 188 AD 3D 525 in 2020. In that case, the plaintiff's expert found that the step was dangerously worn and sloped. The appellant tries to distinguish that case in their reply brief at page 9, saying that, well, the expert found that the narrowness of the step made it so that the plaintiff's foot couldn't completely be accommodated on the step. That's the same thing that the expert found in this case.
Except in this video, you have a man go down the very same flight of stairs without any problem. Without any problem. And he wasn't holding the handrail either.
That is an issue of comparative negligence that must go to the jury. the argument hasn't been made that the plaintiff is the sole proximate cause. There can be more than one proximate cause. We are not making the argument that plaintiff doesn't bear comparative fault. That should be left to the trier of fact at the time of trial. But now on this record, at this procedural stage, the question is, does the step constitute an unreasonably dangerous condition? And under the facts that were presented and under the case law that we cite, the answer is yes, and the trial court got it correctly. I see that my time is going to be up. I want to address something that I did not get the chance to
Go ahead.
address in my brief. The appellant claims that
You didn't address it in your brief?
it was brought up on reply.
Oh, okay, go ahead.
Very quickly, it was that the argument that I'm making isn't preserved for this court, or it's barred by law of the case. Number one, this court is not barred by law of the case to find that the worn out nature of the stair creates the question of fact, because law of the case only bars a coordinate court of jurisdiction from changing a ruling. In other words, the trial court might have made a ruling, but this court isn't barred by that because it's a higher tribunal. Secondly, the standard of review on this case is de novo review. You're reviewing this record anew. All of the arguments that
You got it, and you're out of time.
Thank you, Judge.
Thank you.
Very quickly, on the two cases cited by my adversary, on the carry-on case, I think it's very important to note that in that case, the expert found not just that there was a worn step, but also that there was a dangerously low coefficient of friction, and described the step as deplorable and severely deteriorated. And it was so bad that the plaintiff could not put his foot on the tread. It was half hanging off. As far as the DePepin case, again, the step was described as dangerously worn and sloped. There were inconsistent treads, and the treads were too narrow for the plaintiff to put his foot on. Here, plaintiff's expert doesn't claim that the plaintiff couldn't put his foot on it. If we look at the diagram, it shows that if the plaintiff just put his foot on the very edge, it was a little rounded there, and that's probably why he slipped. He took a misstep. And if there is not an actionable condition, it doesn't make a difference if he was partially at fault. If there's not an actionable condition, the defendant cannot be at fault. Thank you very much.
Thank you. Thank you both. Bowden versus Summit Glory. I don't think we have enough chairs up here, so someone is gonna have to sit in the audience, okay? Okay. There's actually a seat. You can sit there if you want. And you can sit over there if you like.
You don't mind, Your Honor, thank you.
No, not at all. Okay. Just now that we have our seating arrangements, you may proceed.
Good afternoon, Your Honors. Amanda Nelson of Cozen O'Connor for Appellant Respondent, Booking.com. This case, the record is absolutely devoid of any evidence of negligence on Booking.com's part. Marlboro has been very clear and very forthcoming. It was their obligation to install the masonite, their obligation to maintain the masonite, their obligation to check every day whether the tape that was holding down the masonite was in place. Meanwhile, Booking.com was an out-of-possession tenant, essentially relying on Marlboro to build out the space. Getting to the contractual indemnification claim, Justice Manzanet, as you said earlier, you are bound by what you sign. Marlboro signs an agreement that says on the very first page, AIA document A201-217, general conditions of the contract for construction, is adopted in this document by reference. That is the document. It is cited throughout the main contract, which Marlboro acknowledges that it authenticated, and that is the contract that has the indemnification provision. Beyond it being adopted by reference, Marlboro again and again admits that that specific provision is part of the contract, that they're bound by it. In opposition, Marlboro raises many arguments several that are raised for the first time on appeal, including that the document was not authenticated, that there's a different date on the document. Another argument that was only raised by counsel below in a memorandum of law, that the AIA 201-2017 general conditions was not delivered. Without needing to go into details, respectfully submitted that none of those arguments should be considered because they were either waived by having not been raised or were improperly raised through the statements of someone who has zero personal knowledge of the facts. Getting to the heart of the matter, to the actual language of the indemnification agreement, it does have a negligence trigger. There's no dispute about that. But that negligence trigger includes not only that they did the work, and not only that Marlboro had some negligent act or omission that gave rise to the injury, but also that if Marlboro's subcontractor or their employees, it's very clear about their employees as well, was negligent, then they're bound to indemnify and pay the attorney's fees of Booking.com. Here, whichever way you look at it, it's Marlboro or it's plaintiff. Whether it's Marlboro for being negligent in their failure to adequately supervise site safety, which they acknowledged was also one of their obligations, or to properly install the masonite, or to properly maintain the masonite, or whether it was plaintiff who wasn't looking where he was going, whichever way, they owe us indemnification.
So it's clear that Bookings had no role at all with respect to this, correct?
The vast majority of...
So essentially, you're seeking a modification so that you'd be entitled summary judgment on contractual indemnification against Marlboro, correct?
That's correct, Your Honor.
As well as common law indemnification.
That's correct as well, but we feel like we have a stronger argument on the contractual indemnification. Very briefly, and frankly, I'm pretty sure that counsel will address this further, as far as the actual Labor Law 241-6 claim. This court has been very clear in Conlin, or in Murphy versus Scametti, and most of your honors were on that panel, that where masonite, in particular for Murphy, masonite, is an integral part of the construction, no liability.
This was not integral part of the construction.
It was in a different...
No way, no how. That
different
argument does
room.
not fly here at all. At all.
Would you agree under Bazdarek? Would you agree that under Bazdarek, which let's assume the masonite wasn't integral to the work, but if it was not properly fixed and not moving, et cetera, just like the plastic sheeting in Bazdarek on the escalator, the Court of Appeals made very clear that you can have something that's integral, but if it's a better, safer way to make sure that's integral, and you don't do it, then you're on the hook under 241, correct?
I can't disagree with that, but it...
But in Bazdarek, they held that it was not integral to the work.
But here, there would have been no way to avoid it. How do you protect the floor below it, the finished
That's
floor?
not what he was
That's not integral
working.
to his work.
His work was different. He was not in charge of putting down masonite
That's absolutely correct. He was...
or removing it or fixing it. That's not what he was doing.
But the overall construction was still ongoing.
Yeah, but that doesn't give you a free-for-all for everybody who's on site, which is what you are suggesting. That's not how our labor law works.
I'm only suggesting that because he was still traversing...
And we have case law on that too, that if you're walking from one place to another place to go get tools and you get hurt because of some negligence by another party, that is actionable. But thank you.
All right, thank you, Your Honors.
Next.
Does Summit want to go first? Because I have to respond to Summit.
Plaintiff goes last. Plaintiff goes last. Who's the defendant?
Good afternoon, Your Honor. May it please the court, Eric Peterson on behalf of appellant, respondent, Summit Glory. Your Honors, really all I wanted to say, and I kind of will agree with everything that counsel said for Booking.com, we took this appeal based upon what I believe to just be a mistake by the lower court in that they failed to address our arguments regarding dismissal of Labor Law 200 or Labor Law 200 and common law negligence. I think the record is very clear that as the owner, we were not responsible. We did not control the work. We did not control the means and methods. We were there for a very short period of time, just once weekly. We're not responsible for overall site safety. And I think that in the court's failure to address our motion, that compounded the fact that they then said, we're not going to address the contractual indemnity claims. So our appeal is both to seek reversal of the court's failure to address our common law and 200 claims to be dismissed, and then on top of that for both contractual and common law indemnity, both against Booking.com as well as Marlboro. Happy to talk about those very quickly. First and foremost, there is a lease agreement by and between with Booking.com, and that particular lease agreement requires them to defend and indemnify us. There is a negligence trigger, and we do feel that they were on site more frequently, certainly, than we were. They had the opportunity to see this. They would have had the opportunity in the sense of constructive notice more so than us. I'm not standing here before the court saying that they were actively negligent. I'm just saying that we are much more removed than they are. Insofar as our contractual indemnity agreement as against Marlboro, the contract itself incorporates by reference the lease agreement. I know it's a little bit of a stretch, but at the same time...
But there's no contract between Summit and Marlboro.
I'm sorry?
There's no contract.
Correct. There is no contract between
privity
Summit
at
and Marlboro.
all.
Well, there is intended beneficiary privity from the standpoint that the contract references the lease to be incorporated and that Marlboro was responsible to be understanding of what the lease required, and the lease requires indemnification, especially for someone's negligence. And I will echo what it is that Booking.com said with respect to the negligence on the part of Marlboro, so I don't take the court's time. Thank you.
Thank you.
Good afternoon, Your Honors. I am Carol Finocchio. I represent the general contractor Marlboro. I'd like to address the indemnification at the outset. First of all, there's no indication in this record that those general conditions were ever given to us. Now, Marlboro...
At what general conditions?
Okay, so both Summit and Marlboro based their claim for indemnification. They're saying that it exists in Article 3.1.8 of the general conditions of the contract, which they say were incorporated into the contract between Booking and Marlboro. So the problem we have here is that when the contract was signed and exchanged during discovery, there were no general conditions. When Summit made its motion for summary judgment, it put in the contract no general conditions. When Marlboro was doing its papers below, it put in the contract no general conditions. Booking exchanged the contract during discovery with no general conditions, and yet in its motions for summary judgment, it annexed the contract through an affidavit of its counsel, and there were a draft of general conditions.
I'm confused a little bit.
Yes.
Your friend refers to the lease between
Well,
Summit and Booking. Is that the contract you're talking about?
No. So, okay, so there's two different contracts. There's the main contract pursuant to which they're seeking indemnity is the Booking Marlboro contract. We're the general contractor, and Booking is the lessee. Summit is the owner. Summit is also seeking indemnification pursuant to the lease. Now, we can, in my opinion, we can knock that out right now because we have no agreement with them. Marlboro has no agreement
Except
under the
if
lease.
your agreement with Marlboro referenced the lease, then
well,
not Marlboro, Booking.
That's right. If they're okay, well, in response to your question, Your Honor, we don't owe indemnity to anybody. With respect to the argument that we owe it to Summit under the lease, we don't, because the lease was never given to us either at the time of contracting. And the and we're not a signatory to the lease.
Of course not.
It refers
But if your contract refers to the lease,
but incorporation.
don't you have to make it your business to get a copy of that lease so you know what you're obligated to?
Your Honor, our brief has many cases that say.
Did you answer my question? Do you not ask for the lease? That you have a contract you just signed that says you're subject to this lease and you don't ask for a copy of it?
The case law says that if you're going to incorporate terms and conditions into a contract, you have to give the person the terms and conditions. You have to give them the incorporated document.
So you can avoid your obligation by not asking for it if they don't give it to you?
Well,
If there's been some kind of, oops, I forgot to attach that in the email. So you tell them nothing so that you can play gotcha?
No, Your Honor, that's not what I'm arguing. I'm arguing that the case law is clear that if you're going to incorporate terms and conditions, especially if they include an indemnification clause, you can't just refer to it. You've got to include
And you're
incorporated
saying
terms and
there's no
conditions.
indemnification clause in your contract with Booking?
No, in the actual contract, there's no indemnification clause. They are basing their claim for indemnification on general terms and conditions of AIA 201, I think it's 207, I get the numbers mixed up. But they're basing it upon something that was never given to us at the time of contracting. And when you look at the documents...
And you never got it? Because you keep saying at the time of contract.
And even during discovery, when the parties exchanged discovery, when Booking gave us their contract and we gave them the same contract back, it didn't have terms and conditions. Under CPLR 4540A, which is in our brief, we authenticated the contract without general conditions, and therefore there is no indemnity. That's our argument.
Thank you.
Thank you, Your Honors.
May it please the court, Brendan Fitzpatrick, counsel for Cord Contracting. I'll be brief, Your Honor. We were granted summary judgment in September of 2022. No one appealed that decision. In subsequent motions, Summit and Booking tried to seek contractual indemnification. We pointed out the trial court's prior decision. In this decision that's now before this court, the court actually said their arguments were moot because we had already been granted summary judgment. The only reason I'm here is because of point 3 in the brief by Marlboro, which was filed on March 14th of this year, where they said they don't want to pursue anything right now against my client because they want to file a judgment, and that's what they're trying to do at the moment. So they're trying to file a judgment in the trial court right now. Unfortunately, the end of the...
A judgment for what?
Well, in page 1683 of the record, the prior court's decision said the clerk is directed to enter judgment from after the...
So that would be you entered judgment that you're out of the case.
Yes, the clerk, the court directed the clerk to enter judgment. We submitted at least 4 proposed judgments to the clerk. And that's at NICEF documents.
Yeah, we believe you, okay. Heard this one before.
We tried to hand deliver them. The clerk told us we were not going to accept them. Now, 2.5 years later, Marlboro is now trying to resurrect this.
So you were let out of the case, nobody appealed it.
Nope.
And somebody's trying to bring you back into the case.
Yes. Now, again, our papers are part of this record.
You're the employer, right?
Yes. Okay. We, again, the decision...
Board.
Yes. The decision that let us out is page 1681 to 83.
Yeah,
details everything. I'm not going to belabor this court with that, with the arguments and what the court found.
I got that one.
Yes, but I think with respect to what's presently going on, again, our papers were in this record. We just asked for some kind of finality, that we be ultimately granted summary judgment and the case dismissed. So at some point we can close our file and our client can stop. We can stop billing our client. So. Thank you, Your Honor.
Thank you.
Oh, God.
Afternoon, Your Honors. May it please the court, Nicholas Bagley for plaintiff respondent. I'll be brief because it's late, but the lower court properly granted summary judgment for plaintiff based on 241-6. And if I could address Summit's point as to the denial of the dismissal of the Labor Law 200 and the general negligence, it's clear that an owner has a non-delegable duty to maintain their premises, as Summit did in this case. In a case called Bolson v. UJA, which Judge Shulman was on the panel, it's almost identical to this case, where masonite was used. The owner hired a contractor to place that masonite, inspect that masonite, and maintain that masonite. And the defendants failed to make out a prima facie case showing that they lack notice. I mean, it's basically identical.
Did I misunderstand? Did the attorney for Summit, that's what you're talking about, right? Did the attorney for Summit say that the court below, and I have to look at it again because there's so many moving pieces, did not deal with the 200 common law negligence? They didn't grant it or deny it, they just didn't deal with it?
The judge denied it completely as to those provisions. They denied all defendants' motions for summary judgment based on
200 and
dismissal 200, yeah, to dismiss 200. That's what happened in that underlying case.
Okay.
Okay.
So you're saying they have a non-delegable duty, and that's why it should stay in?
Yes.
Even if you have nothing to do with the means and methods of the actual notice of the condition, if
Correct.
you're never there.
Correct. The case is clear on Bolson v. UJA.
Right, but this is, this,
It's condition. This is a defective condition situation.
you're arguing this is a defective condition, but it's also a means and methods of the work, no? I mean, they chose to protect the floor with the masonite.
Correct.
And that was a strategic decision construction-wise.
Which in then turned to a defective condition of the premises when they allowed it to remain that way. They were supposed to remove it basically immediately. They had a final inspection on the 11th of July. The accident.
They were still working up there.
Well,
So are you suggesting that that masonite should have been removed from the floor and that because it constituted a defective condition, or that they failed to properly keep oversight over it so that it would not become a defective condition?
Well, they did the walkthrough on the 11th, right? And then they were going to remove it on the 14th, by the 14th. As soon as my client's accident happened, they immediately removed it, right? And then they continued work for 2 more weeks.
Okay, we obviously can't really use that because now I don't know that evidence would ever see the light of day in a trial.
It's not necessarily a subsequent remedial measure. It goes to show that
One can argue that they want to make sure that doesn't happen again, so let's remove it. I'd rather deal with, the damage to the floors than damage to a person, right? So,
Counsel, you were awarded summary judgment on your 241 claim, correct?
Yes, 241.
So that means someone's on a hook statutorily, and if they get contractual indemnification from everyone else down the food chain, you ultimately get what you're going to get, right?
Yes.
Okay.
okay. All right. 1 minute you have 1 minute.
Just briefly to address the claims made regarding contractual indemnification, this court in Liberty Management made it very clear that yes, where a contract references and incorporates a provision, especially a provision like this.
How do you deal with her argument, though, that they weren't provided with the language?
Sure. So
what proof is there in the record that you did?
There is their own client's testimony, at least, that he was well aware of the AIA 201-2017 terms and conditions. And then beyond that...
But if he never received a copy of it, he can know that there is a form called the A1 blah, 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 conditions, right? But if I haven't received them, how does he know what's in them?
Because they're very specific trademarked terms and directly identified. So that was the same exact issue in Liberty Management, except there the question was whether arbitration would apply as opposed to indemnification. But where it was not delivered, and there was actual testimony that it was not delivered, not just a memorandum of law statement by counsel, that provision, those general conditions were still adopted. And then just, if I may, looking at 1805 of the record, number 2, this is Marlborough's response to the statement of facts. Number 2 is Marlborough admits only that the booking Marlborough contract incorporates the provision cited in paragraph 2 of booking statement of material facts. And that paragraph 2 is the indemnification provision. So to say we had no idea what this was and this just caught us by surprise, especially when the general conditions consider everything from not only indemnification to the right to terminate to how payments are made. It defies logic, Your Honor. Thank you, Your Honors.
Thank you. And last but not least, Jeffries LLC versus Izzo Capital. And you all get the award for patience. Thank you. You may proceed.
Thank you, Your Honors. Richard Corby, on behalf of Izzo Capital, the appellant in this matter, seeking to reverse the lower court's confirmation of an arbitration award.
Sir, would you agree that it's undisputed that you sought arbitration, correct?
Correct.
Okay, and it's undisputed that FINRA rules apply, correct?
Well, FINRA rules incorporating applicable federal law under it, so it's
Bear
not
with me.
only FINRA.
So- And we also know that it is undisputed, and again, correct me if I'm wrong, that unless shares of a bankrupt entity, and here we're talking about the 7 short position companies, are formally deemed, I don't like the word deemed, formally determined and declared to be null, void, and of no effect by the depository trust company, DTC, then they're still in play. Or you don't agree with that?
That's incorrect, Your Honor. The federal court orders control, and this federal court orders specifically say these shares are canceled, extinguished, and deemed of no value, and that's also in accordance with the federal statutory bankruptcy code, section 1141C, and which is controlled by the bankruptcy clause of the United States Constitution. It's very simple. It's a express and field preemption issue. The bankruptcy code and the bankruptcy statute controls, not FINRA rules, not a DTC operational agreement. It's very clear that you can't have a FINRA arbitration panel composed of some retired lawyers saying, well, the statute doesn't apply, or I don't have to follow those court orders. Court orders control, and they specifically matter, and these court orders control this matter. Getting back to, I know the vacating an arbitration decision is a heavy, heavy burden.
Very.
And I believe we fit that case perfectly for what I just said. This is the federal bankruptcy code controls, U.S. bankruptcy clause of the U.S. Constitution controls, and the federal court orders control. That is why the court should reverse the Supreme Court's decision that confirmed the arbitration.
Well, they seem to completely disagree with you on that. They say that the sections of the bankruptcy code upon which you're relying do not apply at all to the claims at issue in the arbitration. So somebody's right and somebody's wrong.
They're wrong, respectfully.
Well, what specific sections do you say apply here that the arbitrators did not use in issuing their award?
Bankruptcy Code Section 1141C, property dealt with by the bankruptcy. It has nothing to do with participation or people being on notice. If it's dealt with by the bankruptcy, that is what controls. And that was specifically recently last summer in Bed Bath & Beyond in the 16B litigation. The shareholders' claims there were dismissed because the shares were deemed extinguished, discharged, and released pursuant to the bankruptcy plan.
So, I read that I guess the arbitrators accepted their argument that there was still risk there, even though the securities had been canceled in bankruptcy because the trading market had opened after the cancellation and the securities were still trading. Now, I'm not exactly sure how that happens, but that's what they say, and that's what the arbitrator, I think they'll tell me.
There was no reasoned decision in the arbitration award, but
I understand that.
Jeffries' own account statements at the record 271 to 275, 287 to 291, Jeffries explicitly says these shares have zero market value
are negative equity. There's no risk for them. How can?
Well, they explained that somehow there was still risk. I mean, understand that's the issue because there was still a trading market had opened up after the cancellation.
I think with the arbitration panel made a mistake in misinterpreting how these documents work. I know it was a 2,800-page record. My apologies.
I still don't, I'm still trying to understand how you get past the law, the plethora of law that says that even if we were to find that the arbitrators made a mistake, applied the wrong law, did not follow a case, that is not enough for us to vacate an arbitrator's finding.
Actually, that is enough for you to, because what the law requires, may I finish?
Yes.
In the Denson case that I cited extensively in my pleadings, an award can violate strong public policy only where a court can conclude without engaging engaging in extensive
What public policy is implicated here?
Not following a federal bankruptcy court order, the statute. I mean, order.
All right, I'll hear the other side.
Good afternoon, Your Honors. May it please the court, Jessica Brody for the respondents. This court has recognized time and time again that the ability to review an arbitrator's decision is extremely limited, and the arbitrators must be confirmed if there's any colorable basis to do so. This arbitration award followed the parties' contract to the letter and was supported by substantial evidence.
Are there any cases that say that, because almost every single appeal to vacate an arbitration award raises the argument that the arbitrator made a mistake. So are there any cases that say where arbitrators make mistakes that is a violation of public policy, that we can just set aside arbitration rulings? Because if that were the case, I think we'd be doing this every day.
That's exactly right. There are no cases that say that, and in fact, the cases repeatedly say the opposite, which is that a violation of law, which I don't think happened here, but a violation of law by the arbitrators is not a basis to vacate, because the arbitrators have the right to rule equitably, find facts, and all of that. And that's what the arbitrators did here. They rejected the argument that Izzo's pressing now about the bankruptcy court orders because they do not apply to the situation.
Right. Let's talk about that. Section 1149 would require that one of the parties here be a debtor, issuer, or equity holder, or creditor, or general partners in the debtor. Is that the case here?
That is not the case here. Izzo is none of the above. Izzo is a short holder with obligations to Jeffries, its prime broker, and obligations to the other parties, third parties, who lent securities to allow it to put on very lucrative short positions.
Right.
So no, the bankruptcy court orders do not apply here. The arbitrators also granted Jeffries requests for affirmative relief. The arbitrators correctly ordered Izzo to comply with paragraph 61 of the customer agreement and take down websites that misuse Jeffries' name. Izzo doesn't dispute that its conduct was a violation of paragraph 61. It only disputes the relief that was ordered on First Amendment grounds, but there's no First Amendment claim here. There was a private contract, and the cases that Izzo cites don't address that situation. Enforcing that order is exactly the same as enforcing NDAs and confidentiality orders that this court enforces all the time. And finally, the panel was correct in ordering Izzo to pay Jeffries $1 million in legal fees. Izzo forfeited any challenge to that by failing to raise it at the Supreme Court below. And beyond that, the fee award was amply supported by evidence submitted at the arbitration. It was more than reasonable, and Izzo has admitted here that the contract allows for fee shifting. And so we would ask this court to affirm the Supreme Court's decision confirming the arbitration award, and consistent with that award, confirm that Izzo must pay post-judgment interest through the date of payment. Thank you.
Thank you. Hey, you have 2 minutes.
I think I'll only use 1 minute of my rebuttal time to get my salient point out. First, the bankruptcy orders do apply because the property at issue in a bankruptcy case that was dealt with during the bankruptcy. That's what the statute says. You don't have to participate. And we even cited in our reply brief Gordman's, where my client sought a comfort order that the shares in that plan were deemed canceled and extinguished. Our client, the court never made any requirement that the parties had to participate in the case. The orders affect everyone. And going back to the Bed Bath & Beyond decision, where the shareholders' claim there was dismissed, they didn't participate in the bankruptcy case either, and the court found that that was irrelevant because the shares were deemed canceled and extinguished.
But do you dispute that despite the cancellation by the orders and your perceived, the perceived take of the zero values, that there was activity on the shares post bankruptcy, correct?
No, that's
I mean, there was evidence, in fact, on record 2940 to 42, there was record of securities being dealt with. And in fact, not all of them, one of these 7 positions was a Chapter 7, which is very different than a total bankruptcy where things are at play. I mean, I'm not going to go into everything that the arbitration, but they heard a whole lot of information.
Well, I'm going to clarify that. Chapter 7 is a straight-up liquidation, so the shares would have no value in the bankruptcy. And at Chapter 11, you can reorganize or liquidate. In the 7 cases, 6 were Chapter 11, 1 was a Chapter 7. All the shares were canceled and deemed extinguished.
Okay.
And with that.
Thank you.